Yes. The
Not
pet.
argue on merits, you argue on the date,
Okay, my lord.
where you are largely reluctant to argue, of course. But anyway, that's your privilege. କେତେ କଲେଣି କିଛି କାଉଣ୍ଟ ରଖୁନାହାନ୍ତି ଆପଣ ପେଣ୍ଡିଂ କେତେ ରଖିଛନ୍ତି ପେଣ୍ଡିଂ କେତେଟା ଅଛି ସଂଖ୍ୟା ତଳେ ବସନ୍ତୁନି ଛିଡା ହୁଅନ୍ତୁ ଛିଡା ଏବେ ତଳେ ବସିଗଲେ କଣ ହବ ଭୋଟ ସରିଲା ପରେ ବସିବେ ନା ଆପଣ ପାଖରେ ଆପଣ ଫିଗର ରହିବା ଦରକାର କେତେଟା ଆପଣ ଲିଷ୍ଟ କରୁଛନ୍ତି ନା ମୁଁ କେମିତି ଜାଣିବି ଆପଣ କଣ କରୁଛନ୍ତି ସାର୍ ମେମୋ ଦିଅନ୍ତୁ ସାର୍ ମେମୋ ଦେବେ ପ୍ଲିଜ ଗିଭ୍ ୟୋର ପେଜ ୱାଇଜ ଡାକନ୍ତୁ
Page 1, item 1 to 9.
ठीक सर.
just say it will be immediately it will reach just give us a memo yes
Page 2, 10 to 10, 11. Item number 10 will not.
yes please
Submit it. Worship, it's for
ଆପଣ ଚାହୁଁଛନ୍ତି ଆପଣ ଡେଟ୍ କରିଦେବେ ହେଲା
16
16/2 we commencing 16/2 quick
Page 3, 12 to 20.
মানে আইটেম নম্বর 14
14
মাইল
adjournment ଚାହୁଁଛନ୍ତି
মাইল
orders matter
ମାଇଲ
ଠିକ ଅଛି
16
Item number 12 also.
ସେଟା ରଖନ୍ତୁ 16/2 ଭିତରେ ଛାଡ଼ିଦେବେ ତା ପୂର୍ବ ନା ତା ପର 16/2 ରେ କିଛି ଆଟ ରଖନ୍ତୁ we commencing 23/2 ଆପଣଙ୍କ ମ୍ୟାଟର
ମାଇଲ
ପଟ୍ଟନାୟକ your matter yes sir
Item number 12. Item number 12, Your Lordship.
ha
Your Lordship, we have filed a requisite today itself. Like,
sir we are mention only no orders on merit please appreciate that. If you are making a mention it will be recorded if you want adjournment kindly mention I am not taking up your matter out of turn yes next please
Lordship, me item number 17, my lord.
yes 17 adjournment हाँ देख कर दियो 17 adjournment we commencing 23 just accommodate that 16 2 week either before that or after that 23 हाँ ठीक है
Page 4, item 21 to 28. Page 5, 29 to 35.
Item 35, madam.
Yes, please.
I am for the appoint party.
yes please Sumanti
I'll counter.
date माइल 35 टा डेट कर देवे
Well, interrupt to continue.
no order is passed so it will continue There's no-
Item 30.
we commencing do it Mr. Mahanti and Mr. Ray
Item 30, my lord.
31 sir yes please
31.
हाँ
I am there for adjournment.
आर साइड को इन्फॉर्म करनाहांती
ନା
ସେଟା ମୁଁ କେମିତି କରିବି ମୁଁ କଣ ଆର ସାଇଡ୍ पे appear କରୁଛି
ନମ୍ବରଟା ଲାଗିଲାନି
ଆଜ୍ଞା
କଣ୍ଟାକ୍ଟ ହେଇଥିଲା
ମୋ ପାଖରେ କାର ନମ୍ବର ବି ନାହିଁ ଯାହା ନମ୍ବରଟା ଡିଲିଟ କରିଦେଇଛି
ମାନେ
କଣ
ଆଇଟମ ନମ୍ବର 25 ମାଇଲ
ଠିକ ଅଛି ଡେଟ୍ କରିଥାନ୍ତି
Nothing. Who comes?
ଆପଣ ମୁହଁକୁ ଦେଖିଲେ ଲାଗୁଛି ସେ ଅବଜେକ୍ଟ କରିବେ ବୋଲି ଏନିୱେ ସବୁଦିନ ସେମିତି କିଛି ଅବଜେକ୍ସନ ହଉଛି 9/3/26 ୱିକ୍ କରିଦେଉଛି
Page 6,
My lord, item 37, my lord.
yes
This such a matter relates to paddy procurement. But as per your lordship direction, I moved before the DR. DR can without the order of the honorable court, I cannot change the assignment.
ଆପଣ ଆଉଟ ଅଫ୍ ଟର୍ନ ଟେକିଂ ଅପ୍ ନବା ପାଇଁ ଚାହୁଁଛନ୍ତି
They are not assigned to this one. Matter relates
ପ୍ରୋକ୍ୟୁରମେଣ୍ଟ ମୋର ଡିଷ୍ଟ୍ରିବ୍ୟୁସନ ପ୍ୟାଡି ଡିଷ୍ଟ୍ରିବ୍ୟୁସନ
this matter relates to paddy procurement.
ଆଚ୍ଛା ୟୁ ଆର୍ ମିଷ୍ଟର
Sorry, on behalf of submitting on behalf of Mr. Mahanti.
because sir your full name is
This is right. I am one of the.
नहीं कर दे हाँ ठीक है procurement pad sure ठीक है the order has to be passed to be listed before the assembly the procurement और distribution ने कहीं चोरे एपट से पट ही जाऊँगी
Paddy procurement is coming under the agricultural marketing production.
market producer वो तो
That is the
procurement
scheme.
matter एटी पड़ेगा any other matter last
my lord, sir. Yes, my lord, item 36, my lord.
yes please
My learned friend is there, my lord, other side. My lordship, kindly take
date code 36
Yes,
है
yes.
Will commencing law in.
My lord, sir, short date.
ସର୍ଟ ଡେଟ୍ ହେଲେ ହେଇପାରିବ ଅନଲିଷ୍ଟ ହେଲେ 23/2 ହେଇପାରିବ 23/2 ନହେଲେ କଣ ସେଟା
Not
8 ତ ଆଇଦର 2-3 actually 2-3 ୱିକ୍ ରେ 3ଟା ୱାର୍କିଂ ଡେ ଅଛି so that is some
23rd.
ଠିକ ଅଛି 2-3 ରେ ରହୁ କମେନ୍ସିଂ 2
Right. Item number 25 minute. Adjournment.
25 ठीक है मैं पूरा फेज 6 रे अच्छे 25 आइटम कहतु
Adjournment, my lord.
अच्छा यू आर ऑन बिहाफ ऑफ मिस्टर पृष्टि
Aye.
यंगर मिस्टर पृष्टि এটা 25 টা ডেট
Sagar Prishti.
not will commencing law.
नॉट इन वीक अब
Sagar Prishti. Expression.
यस
Page 1, item 1,
मेमोटा दियो मिस्टर रविंद्रनाथ बारिक फॉर द पिटिशनर the application has been filed. Kindly take your seat. Just 2 minutes. I'll take to dictate the order. So, area maintenance file है. Withdraw कर दूँ. मिला area maintenance मिला. आगे. ମାନେ କାମ କଣ ହେଲା ଆପଣ ଯୋଗାଡ଼ କରିଦେଲେ ଟଙ୍କା ନା କଣ ଏକ୍ଜିକ୍ୟୁସନ ହେଲା ନା କଣ The petition has been filed by the wife in the marriage. Seeking the following direction. Direction that quote कर देना. Stop. Today, when the matter is taken up, memo on behalf of the petitioner is filed by the पूरा नाटा लिखी देवे. Short signature केवल लिखी हुई. A place date लिखी. But the memo of date is filed by the learned counsel for the petitioner. And not to waste the application. The memo is taken, stop, memo is taken on record. The petition stands disposed of. Yes, next please.
item 2,
May I please lordship?
Yes.
On behalf of SK Bhanjidev.
You are Mr. Behra.
No, on behalf of SK Bhanjidev. I'm
On behalf of
Bablu Barik. On behalf of Sanjay Kumar Bhanjidev.
Mr. Bablu Barik on behalf of SK Bhanjadev. Yes, please.
I am for the petitioner husband.
Yes, yes.
Here in this case, the petitioner challenging the order dated 21/3/24 passed by the learned judge family court
Yes.
in CP case number 197/22, directing the petitioner to pay monthly maintenance of 5,000 to opposite party number 1 and opposite party number 2 3,000 for monthly maintenance.
Yes. Kindly address on the grounds of challenge. এটা correction ହେଇନି ତାପରେ
No, for the first time.
concentrate on the subject. Order ଟା 5+3 କେତେ 5+3 ହବ 8
Yes, lordship.
18 ହେଇଯାଇଛି correction ହେଇନି
No, lordship.
এটা তো ଏଠି ହେଇପାରିବନି original order cannot be corrected by the court but ସେଠି correction କରିବାକୁ ପଡିବ
Lordship.
କଣ କରିବେ
Only withdraw କରିଦେଉଛି।
ନାଇଁ withdraw କରନ୍ତୁନି amendment file କରନ୍ତୁ
Lordship.
ଆପଣ ଯିବେ ସାର୍ଟିଫାଇଡ୍ କପି ଦେଇଛନ୍ତି ଏଠି
No,
ବ୍ୟସ୍ତ ହୁଅନ୍ତୁନି आई एम जस्ट इंटरेक्टिंग विथ यू
Hmm.
आपण जदि गोटे ऑर्डर रे भूल हैला 5,000 युक्त 3,000 केते हबो
8,000
एठी लिखा हैला केते अरे डोंट यूज योर स्पीड while turning the pages
Notes.
पॉज रखंतु इंटरनल पेज 12 रनिंग पेज 12 देखो चेप मारंतुनी चेप मारे अभ्यास छाड़ंतु से रखले केमती हम आप बर्तन काढ़ु तो गोटे हाथ धोया गोटे ढाल पानी रखा पड़ो आप लेके आस
18,000
गोटा कौन मुझे देखी
8,000
सेटा करेक्शन करियोनी देयर कैन नॉट बी एनी चेंजेस और इंटरपोलेशन
लॉर्डशिप
द रीजन होची इट कुड बी 15 + 3 आल्सो बुझ परछनी
लॉर्डशिप
तो सेटा को करेक्शन करिकी ताकू लेट काउंट एग्जीक्यूशन फाइल हिची ठीक अच्छे had learned counsel for the had Mr. Barik learned counsel for the petitioner. He has adjournment to verify the discrepancy in the ordering portion of the order of the court, which is under challenge. এটা আপনার প্রেয়ার না এটা অর্ডারটা
order
order no ପିଟିସନଟା ଭୁଲ ଅଛି ସେଟା ଠିକ ଅଛି ଦେଖନ୍ତୁ ଆପଣଙ୍କ ପାଇଁ ବି ମୋର ଲ୍ୟାପ୍ସ ଅଫ କନସେନ୍ଟ୍ରେସନ ଏନିୱେ କଣ ଗ୍ରାଉଣ୍ଡସ୍ କଣ କୁହନ୍ତୁ ଚ୍ୟାଲେଞ୍ଜର ଗ୍ରାଉଣ୍ଡ बी कॉन्फिडेंट किसी व्यस्त होतुन किसी तो एडवर्स ऑर्डर हबार नहीं ଦି ଜଣ କାହିଁ ଚେପ ଲଗାଉଛନ୍ତି
the petitioner is a daily laborer earning 100 to
Very
12
good.
per day for fishing in a
ବର୍ତ୍ତମାନ କେତେ
ଏବେ 250 ରୁ 300 ହେଲାଣି
ସେ ଯାହା ପାଖରେ ଏମ୍ପ୍ଲୟର ସେ ତ ଆରେଷ୍ଟ ହେଇଯିବେ ମିନିମମ୍ ୱେଜେସ୍ ଆକ୍ଟ ରେ ଏଟା ଆଫିଡେଭିଟ୍ ଦେବେ 250 300 ଯିଏ ଦଉଛନ୍ତି ତା ନାଁ ଡିସକ୍ଲୋଜ କରିଛନ୍ତି ରାୟ କୁଆଡେ ରାୟ ଥିଲେ ଏଠି violation of labor law has some stringent provisions minimum wage act violation बहुत जिनस स्टेटमेंट कोर्ट ଦେଇଛନ୍ତି ଲୋअर कोर्ट रे देखंतु 250 पाउଛନ୍ତି बोली कोर्ट डील ହେଇଛି
Notes.
ଏଇଟା ଗୋଟେ କଭର ଅଫ ଅପରେସନ ନୁହଁ ଜୁଡିशियल प्रोसेस अपील और ट्रायल कैन नेवर बी ए कवर अफ ऑपरेशन
Notes.
काहेंगी सो बारिक व्हाई इट कैन नॉट बी ए कवर अफ ऑपरेशन कौन लिखा है कि कौन सत्यमेव जयते आपण सत्यर अनुसंधिष्चु सत्यर अनुसंधान करछन आपण जदि कवर अप करिवे 250 टंका तले पूराटा कहिबे कि 250 टंका दउची का पारे काम करछन्ती ताको एग्जामिन करिवे भाउचर देबे काई आपण लोअर कोर्ट जो कहउचंती सेटा ଗୋଟେ ग्रेट कोर्ट दैट इज इन इंटरफेस विथ द पब्लिक 125 सीआरपीसी पढिचंती कौन लिखा है मजिस्ट्रेट अपन गोटा देखंतु जो ग्राउंड आर्ग्यू करिवे बोल्डली कहंतु हेइथिबो से 50 टका पाउथिबो बट जज केमती जानिबे
Notes.
आपण तेणु एई जो बैटरटा एटा आपण देखैबे कोर्ट रे जागा मु तो डेली लेबरर मु 250 टका पाउची जी राम जी रे बर्तन वेजेस केते एम्प्लॉयमेंट गारंटी रे जोटा मनरेगा थिला सब बेले गोटे आपण यू आर द क्रीम ऑफ द सोसाइटी एज फार एज लर्निंग इज कंसर्न सब विषय जानछन्ती पढिछन्ती केमती एडा कहिबे से कोर्ट रे कोन लेखि अरे तापर से काटी देबे वो प्रेयर रे भूल अछि सेडा प्रेयर ता 5+3 18 होई जाई the learned counsel, Mr. Barik learned counsel was heard for the petitioner for some time. He has adjournment, stop, he has adjournment to address on the grounds on which the order dated 21/2/2024 passed by the learned judge family court Khurda in CRLP number 197 of 2022 granting maintenance of rupees 5,000 per month to the petitioner wife and infant child rupees 3,000 per month. So, the said application was allowed. The said application was filed by the wife in the marriage as well as the infant born from the wedlock under section 125 CRPC into bracket since repealed bracket close. Was filed. Let's put a sentence complete and full stop. Yes, think on this. आपण जो जगह रे केस करछंती से जगह विषय जानछंती भूषणपुर रे सेठी आपनकर माछ धरंती अपन सेपट एरिया लोक ना कुपट
ना
तो से भी सब प्रॉब्लम अछि व्हेन यू स्टार्ट कवर अप पण बहुत दिन से कवर करिया पड़ियो ओटा कि इम्पॉसिबल सेते बड़ कना बा सेते बड़ कवर सृष्टि करा हिनी सब जिंस कवर कला भलिया तो तुलेबो ना तब धारणीय लेखा हला आमे तब जदी कवर करिया केमति हबो ना एपट हबो ना सेपट हबो yes next this is only to encourage you prepare and you have to be straightforward to your client that these are not आपण कर काम नु जे तांकर से पैसा देबे नै आपण कवर पेठी करिवे आंसर किए देबो से निजे करंतु निजे आंसर दियंतु लो कोर्ट रेकॉर्ड ता सब देखि की प्रिपेयर करियो कोन एविडेंस थिला कोन थिला स्टेटमेंट कोन थिला मिस्टर महंत प्लीज मिस्टर एचके महंत
Item 3,
केबे केबे मिस्टर बारिक सॉरी मिस्टर बारिक केबे आसीबो आपण केबे केते सप्ताह परे ना केबे आसीबो आसले हबो
फेब्रुआरी
आगे फेब्रुआरी 9 तारिख ले हबो वी कमेंसिंग 9/2 कर दियो तो लिस्ट फॉर फ्रेश एडमिशन वी कमेंसिंग नाउ yes
Here, Your Lordship, I have to pay 1,000 rupees to my senior to WhatsApp.
दिया है नहीं
Nine. In course of the day,
how ठीक है pursuant to order dated Mr. HK Mahanta for the petitioner Mr. Suryakanta Das for the opposite party the learned counsel for the petitioner refers to order dated 8/12
नहीं
6/1/2026 wherein the coordinate bench had directed for payment of cost of rupees 1,000. Stop. He submits that the said amount has not been paid and maybe he may be granted further time of 3 days to pay the amount.
Okay.
Stop. List under the list for fresh admission in the week commencing 9/2 9/2/2026.
Item 4,
Item 4, on behalf of Mr. Panda, I may be permitted to withdraw to file appropriate application.
But he has to file application memo.
Yes, sir.
Whenever there is a withdrawal,
Yes,
the
sir.
advocate on record has to file. You cannot file.
Yes.
So you file that. You are also Ms. Panda.
Yes, sir.
Mrs. Panda on behalf of Gyanananda Panda for the petitioner. Memo ta deleni?
He has some medical emergencies, so
Asibe.
asi.
Pore debe.
Aye.
Court master ko debe.
Aye.
Pore apon memo asile tai dekhi karibo. Apon pura nada sorry bhuli gali.
Sonali Panda.
Mrs. Sonali Panda. On behalf of Mr. Gyanananda Panda. J. N.Y. Gyanananda Panda for the petitioner. Memo is filed by the learned counsel for the petitioner. Memo of date memo of date today. Aji date re debe.
Yes, sir.
So memo is taken on record. The petition stands disposed of.
My lord,
With liberty to file the petition with better particulars.
certified copy may kindly be written.
The certified copy filed along with the petition shall be returned to the learned counsel for the petitioner after the said certified copy is replaced by a attested photocopy. Yes, next. Yes. Mr. Das. Yes. Mr. Kishore Chandra Das for the petitioner. Yes, please.
Your Lordship, petitioner prays before this honorable court to transfer the case, city case number 39 of 2025 from the Law and Additional Session Judge Special Judge Dharmagada Kalahandi to the ADJ Special Judge Bhubaneswar.
What is the matter? What is the case about?
Lordship, the allegation made by the petitioner against the accused section 69 of BNS and also section 3 of the SC/ST Act. And Lordship, the petitioner is sought not mere convenience, but on a reasonable and bona fide apprehension of denial of fair trial. Because the
No,
accused,
this is my whether this I have assignment of this. This is not relating to matrimonial matters.
is not matrimonial, a criminal case, Lordship.
More bodhe nahi seta. So Lenka ka also kindly examine. Na sabu TRPC eche asio. TRPCR lega TRPCR. FIR कोटी फाइल ହେଇଥିଲା
Junagadh police station.
ତାହେଲେ କେମିତି jurisdiction କେମିତି ଆସିବ ଭୁବନେଶ୍ୱରର?
The Lordship, petitioner has taken the rented house. ରହୁଛନ୍ତି
ଘର jurisdiction ଆସିଯିବନି।
petitioner ଘର ମାନେ
ଆପଣ ଯଦି FIR ଦେଲେ
ଆଜ୍ଞା
ପ୍ଲେସ୍ ଅଫ୍ ଅକରେନ୍ସ ଜୁନାଗଡ଼
place
ଭୁବନେଶ୍ୱର କେମିତି ଟ୍ରାଏଲ ହବ? ଆପଣ ଭୁବନେଶ୍ୱର କୋର୍ଟର jurisdiction କୁ ଆଣିବାକୁ ପଡିବ ନା।
ଆଜ୍ଞା ଭୁବନେଶ୍ୱର
ଏଇଟା ଗୋଟେ ଇଏ ନୁହଁ, ଏଇଟା ମ୍ୟାଟ୍ରିମୋନିଆଲ ମ୍ୟାଟର ନୁହଁ। पण इन्वेस्टिगेशन केमती हबो चार्जशीट केमती फाइल हबो
चार्जशीट ऑलरेडी फाइल बाय दी
ताले से साक्षी को एग्जामिन हेबे भुवनेश्वर रे केमती हेई परिबन सेटा
तो भुवनेश्वर
आपण को जुनागढ़ इंसिडेंट ता
वाइटल विटनेस आर रिजाइडिंग इन भुवनेश्वर
सीटा आपण जणे लोक अमेरिका रह कि इंडिया रे क्राइम कला ट्रायल कोठी हबो अमेरिका ना इंडिया रे अमेरिका रे हेई परिबन सेटा
अमेरिका इंडियन ऑफेंस करची तले
तो ऑब्वियसली पण आपण को जोठी ऑफेंस हला जोठी तार जुरिसडिक्शन आसला सेठी इन्वेस्टिगेशन हबो ସେମାନେ ତାଙ୍କୁ ସମନ କରାଯିବ ସେ ଆପିୟର କରିବେ ଆମେରିକାରେ ଆସିକି ଏଠି ଆପିୟର କରିବେ
it is not convenient for the petitioner to continue this case before
convenience who is the prosecutor
prosecutor the petitioner petition
କୋ ପ୍ରୋଭିଜନ ରେ ଅଛି CRPC ରେ ଯେ
447 of the
ସେ prosecutor ଆଗ ଦିଅନ୍ତୁ ତରବର ହୁଅନ୍ତୁନି ତରବର ହେଲେ I may be wrong also first of all don't give knee-jerk reflex reactions which matter other than state the private person is a prosecutor What is the role of informant or a victim?
Informant is in this case the inside of the prosecution.
This is a so and so. Na petitioner versus so and so.
State versus one so.
So ଆପଣଙ୍କର ରୋଲ କଣ ଏଥିରେ? ଆପଣ କଣ କରିବେ ସେଠି ଜୁନାଗଡ଼ ଆପଣଙ୍କୁ ସମନ ଦେଲେ ଯେ ଆପିୟର କରି ସାକ୍ଷୀ ଦେବେ।
ଯେହେତୁ ଆମକୁ ସାକ୍ଷୀ ହେବା ପାଇଁ ଆମକୁ ଧମକ ଦିଆହଉଛି
କୋର୍ଟରେ କାହିଁ ଆପ୍ଲିକେସନ ଦଉନାହାନ୍ତି?
ଆମେ ବିଲଙ୍ଗ
କୋର୍ଟରେ
ଆମେ ସେଠି
ଧମକ ଚମକ ଯୋଉ ଦିଆ ହଉଛି ଆପ୍ଲିକେସନ କାହିଁ?
ଯଦି ଆକ୍ୟୁଜ ଯଦି ଲୋକାଲ ଇନଫ୍ଲୁଏନ୍ସ ଆମେ ସେଠି ଆମ କଲିଗ୍ସ ପିଟିସନ କଲିଗ୍ସ ହଉଛି ଆକ୍ୟୁଜ।
ବୁଝିପାରିବେନି
ଆଜ୍ଞା
ଏଇଟା ଡ୍ରଇଂ ରୁମ୍ ଡିସ୍କସନ ନୁହଁ। ଦିସ୍ ଇଜ ଲିଗାଲି ନୁଆନ୍ସ ଡିସ୍କସନ। ଆପଣଙ୍କର ସବୁବେଳେ ଆକ୍ୟୁଜ ଆଉ ଇଏର କ୍ଲୋଜ ପ୍ରକ୍ସିମିଟିରେ ଥାନ୍ତି ତାହେଲେ କାହିଁକି ସେମ୍ ଜାଗାରେ ଅଲଗା କାହିଁକି? ଇନ୍ ହାଉ ମେନି କେସେସ୍ ଆକ୍ୟୁଜ ଏଇଟା ସାଇବର କ୍ରାଇମ। ସବୁବେଳେ ଆପଣ ଯୋଉ ଅଫେନ୍ସ ଯୋଉ ଦଫା ଲାଗିଛି ସେଇଟା ତ କେବଳ ନୋନ୍ ଲୋକଙ୍କ ଭିତରେ ହିଁ ହବ। ସେଇଟା ଦ୍ୟାଟ୍ସ ନଟ୍ ଏ ଗ୍ରାଉଣ୍ଡ ଟୁ ଟ୍ରାନ୍ସଫର ଏ ପିଟିସନ। ଧମକ ଚମକର ଯୋଉ ଆପଣ କହୁଛନ୍ତି ଆପଣ 3 ଥର ପଚାରିଲେନି କୋଉଠି ଦେଇଛନ୍ତି କମ୍ପ୍ଲେନ କଣ ହେଲା?
ଏକ୍ଜାକ୍ଟଲି ଆମେ ତ ଆମକୁ ଧମକ ବେଲ ଆକ୍ୟୁଜ ବେଲ ହବା ପରେ ଆମକୁ ଧମକ ଚମକ ଦିଆହଉଛି।
କାହିଁକି ଦଉନାହାନ୍ତି ଯେ ଏଇଥିରେ କଣ୍ଡିସନ ଅଛି ଯେ ବାହାରିଲା ପରେ ଧମକ ଚମକ ଦେବେ?
ସେ କଣ୍ଡିସନ ନାହିଁ କିନ୍ତୁ ଯେହେତୁ
ତେଣୁ ଆପଣ ଯିଏ କୌଣସି ଲୋକ ବି ତାଙ୍କର ବି ଓକିଲ ଅଛନ୍ତି ଯେ ସେ କେବେ ଧମକ ଚମକ ଦେବେନି। ଧମକ ଚମକ ଦେଲେ ତାଙ୍କ ବେଲ କ୍ୟାନସଲ ହେଇଯିବ। କ୍ୟାନସଲେସନ ଫାଇଲ କରିଛନ୍ତି?
ଏକ୍ଜାକ୍ଟଲି ଲକ୍ଷ୍ମୀ ସେଇ କଥା ମୁଁ ଯେହେତୁ ସେ ଆମ ଆକ୍ୟୁଜ କଲିଗ୍ସ ଆମେ ଏଠୁ ଯାଇକି ସେଠି ଚାକିରି କରିଛୁ ଆମ ଉପରେ ପ୍ରେସର ପକାଉଛୁ ଆସୋସିଏଟ ମାନଙ୍କୁ ଇଏ କରୁଛୁ
ସେଇଟା ମୁଁ ଟ୍ରାଏଲ କରିବି
ଭୟଭୀତ ଅଛୁ
ମୁଁ ଟ୍ରାଏଲ କୋର୍ଟ ନୁହଁ। ଆପଣ ଟ୍ରାଏଲ କୋର୍ଟରେ କୋଉଠି ଆପ୍ଲିକେସନ ଦେଇଛନ୍ତି?
ସେଇ ଜିନିଷଟା ଆମେ ଚାହୁଁଛୁ ଯେଟା ଭୁବନେଶ୍ୱର ନେଲେ ଆମେ କନଭିନିଏଣ୍ଟ ପ୍ଲେସ୍ ହବ।
ସେଇଟା ଆଜ୍ଞା ଭୁବନେଶ୍ୱର ବହୁତ ଆହୁରି ଭୟଭୀତ ଜାଗା। ଭୁବନେଶ୍ୱର ଆହୁରି ଭୟ ଲାଗିବ
କିନ୍ତୁ ସେ ଜାଗାରେ ଆମକୁ
ଭୟ ଧର୍ମରେ ଭୟ ଲାଗୁଛି ଦେନ୍ ହ୍ୟାଭ୍ ଟୁ ରେକର୍ଡ ଯେ ଭୁବନେଶ୍ୱର ଭୟ ଲାଗିବନି ବୋଲି ଦ୍ୟାଟ୍ସ ଅ ପ୍ରୋବ୍ଲେମ। ଆପଣ ଭାବୁଛନ୍ତି ଆପଣ ଯଦି ଭାବି ପାରିବେ ତାହେଲେ ଆମେ ଆସିଷ୍ଟିଂ ବୁଝିପାରିବେ। ଆପଣ ଯଦି ଜଣେ ଧମକ ଚମକ ଦଉଛି ଆପଣ ୟୁ କ୍ୟାନ୍ ଆସ୍କ any lawyer, Mr. Mahapatra is there, Mr. Lenka is there, they have vast experience. ଧମକ ଚମକ ଯିଏ ଦେବ ତାର ବେଲ ନିଶ୍ଚିତ କ୍ୟାନସଲ ହବ। ଭେରି ଡିଫିକଲ୍ଟ ଟୁ ଗେଟ୍ ଓଭର ଦ୍ୟାଟ୍।
ଆମେ ଏଇ କଥା
ଆପଣ ଭୁବନେଶ୍ୱରରେ ଆପଣ ଯୋଉ ବର୍ତ୍ତମାନ ମୁଁ ଅର୍ଡର କଣ କରିବି ଯେହେତୁ ଭୁବନେଶ୍ୱରରେ ଭଲ ଲାଗୁନି ୱିଟନେସଙ୍କୁ ଭୟ ଲାଗୁନି ଧର୍ମଗଡ଼ରେ ଭୟ ଲାଗୁଛି ଟ୍ରାନ୍ସଫର କରିଦେବେ। Can that be legal ground? That's the question to you.
Convenient there are
Convenient ଦେଖାଯାଉନି।
Supreme Court decisions of the most prior importance given the convenient of the
ନାଇଁ ପଢୁନାହାନ୍ତି ଅଳ୍ପ ପଢିଲେ ସେ ଅସୁବିଧା ହବ। ସେଟା ତ ପଢୁନାହାନ୍ତି ଆଉ ଭାବୁଛନ୍ତି ଜଜ ପଢୁନାହାନ୍ତି। ନାଇଁ ସେଇଟା ପ୍ରୋବ୍ଲେମ ହୁଏ। ସେଇଟା ମୋର ତ କ୍ରିମିନାଲ ପ୍ରାକ୍ଟିସ ନଥିଲା କି ମୁଁ କରୁନଥିଲି ତେଣୁ ମୁଁ ପ୍ରାୟ ପଢାପଢି ସେମିତି କୌଣସି କନସେପ୍ଟ ନାହିଁ ଯେ ୱିଟନେସ ର କନଭିନିଏନ୍ସ ହବ। ଆପଣ ପ୍ରୋଟେକ୍ସନ ମାଗିବେ କମ୍ପ୍ଲେନ ଦେବେ ଆଉ ଯିଏ ଆପଣଙ୍କର ଧମକ ଚମକ ଦଉଛି ତାର କେସ୍ ଗଲା ତାର। ସେମିତି ଆଜ୍ଞା ଆପଣ କଣ ଜାଣିନାହାନ୍ତି କଣ କରାଯାଏ? ଲାଙ୍ଗୁଏଜ ୟୁଜେସ୍ ଟୁ ୱିନ୍ ଓଭର ଦ ୱିଟନେସ। ଆପଣ ଭାବୁଛନ୍ତି ଯେ ହଷ୍ଟେଲ ହୁଅନ୍ତି ତାଙ୍କୁ ଧମକ ଚମକ ଦେଲେ ହଷ୍ଟେଲ ହୁଅନ୍ତି? I should not say this thing, perhaps it is unusual, but since I come from that side also, I know what happens. Don't make it a drawing room discussion ଯେ ତାଙ୍କୁ ଆଜ୍ଞା ଡର ଲାଗୁଛି ଧର୍ମଗଡ଼ରେ ସେଠି ଲୋକାଲ ଲୋକ ଇଏ ଭୁବନେଶ୍ୱରରେ କନଭିନିଏଣ୍ଟ ହବ। She is not the prosecutor. She has to support the case. And you have to produce the entire order sheet. How many orders, directions have been issued to her to appear and how she has responded. ଯୋଉ ଦିନ ତାଙ୍କୁ ଧମକ ଦିଆଗଲା ସେଇଦିନ ଯଦି ତାଙ୍କର ଡେଟ୍ ଥିଲା ସେଇଦିନ ପିଟିସନ ଫାଇଲ କରିବେ ପବ୍ଲିକ ପ୍ରୋସିକ୍ୟୁଟର ଯେ ୱିଟନେସକୁ ଇନଫ୍ଲୁଏନ୍ସ କରାଯାଇଛି ବୋଲି। କାହିଁ ସେଟା ଆପଣ ଟ୍ରାଏଲ କୋର୍ଟରେ ପ୍ରାକ୍ଟିସ କରନ୍ତି?
ଆଜ୍ଞା
ତାହେଲେ ତ ୟୁ ସୁଡ୍ ଗାଇଡ୍ ମି। ମୁଁ ଆପଣଙ୍କୁ କଣ ପଚାରିବି?
ସେଇ ଜିନିଷଟା ସେମାନେ କହିପାରୁନାହାନ୍ତି। ଏଇ ଯୋଉ ପିଟିସନର ଯେହେତୁ
ଭୁବନେଶ୍ୱର କେମିତି ମୁଁ ଅର୍ଡର କରିଦେବି? ଭୁବନେଶ୍ୱରରେ ସେମ୍ କୋର୍ଟ ସେମ୍ ପବ୍ଲିକ ପ୍ରୋସିକ୍ୟୁଟର ଆପଣ ପ୍ରଥମ କୋର୍ଟ ପ୍ରଶ୍ନଟା ଭୁଲିଗଲେ। Same set of facts and circumstances, Bhubaneswar is better, fearless. How can I record that? That will be attributing something to the Dharamgad prosecutor and judge. This is a serious thing. Must realize the High Court commenting on the suppose I believe you and pass an order that the prosecution witness is threatened. That tells upon the integrity of the trial before the court. It's not a small thing to do by a court, by a superior court. ଦେଖନ୍ତୁ ଯଦି ପ୍ରିପେୟାର ହେଇପାରିବେ ପ୍ରିପେୟାର ହୁଅନ୍ତୁ. Don't make empty submissions influenced by the petitioner because they don't read or they don't understand law. ତାଙ୍କର threat perception ସେ ଯଦି ଧର୍ମଗଡ଼ ରହିଲା ଭୁବନେଶ୍ୱର ଆହୁରି threat ରହିବ. How this court will ensure that she is not threatened or influenced in Bhubaneswar when you have nothing to show on record. Bhubaneswar Dharamgad is a bad place to conduct a criminal case when the occurrence is there. Everything happened in Dharamgad.
local influence.
ଆଜ୍ଞା ଲୋକାଲ ଆକ୍ୟୁଜ ସବୁବେଳେ ବି ହେବେ ତାହେଲେ ସବୁ ଜାଗା କେସ୍ ଟ୍ରାନ୍ସଫର କରିବାକୁ ହବ.
witness protection and with victim.
ସେଟା ମତେ କହିବେନି ମୁଁ ଟ୍ରାଏଲ ସେଟା ଆପଣ ପ୍ରଥମେ ପଚାରିବେ ଆପଣ ପିଟିସନ ଦେଇଥିଲେ କଣ ହେଇଛି ସେଟା what happened to your petition?
ପିଟିସନ ଆମେ ଆକ୍ଚୁଆଲି ସେଟା ଫାଇଲ କରିନୁ ତ ଗୋଟେ ଆମେ ଯେହେତୁ ଆମେ ପୋଲିସ ଜଣେଇଲୁ ପୋଲିସ ଆମେ ସେଥିରେ ମୁଣ୍ଡ ଖେଳିବୁନି ଆପଣ ଆମେ କେସ୍ ଫାଇଲ କରିଦେଲୁ ଆପଣ ଛାଡି ବୁଝନ୍ତୁ ଆମେ ଯେହେତୁ ଆମ ଭିକ୍ଟିମ ହଉଛି ଓମେନ
ଆଜ୍ଞା ପୋଲିସ ଯଦି ଏଫଆଇଆର ଦେବେ ସେଟା କିଛି ତାର ଯେମିତି ହେଲେ ଆପଣ ନିଜେ ଏତେ କଥା ଆସି ଏଠି ହାଇକୋର୍ଟରେ କହୁଛନ୍ତି ଆପଣ ରେଜିଷ୍ଟର ପୋଷ୍ଟରେ ପଠେଇଦେବେ. We have converted the courtroom to a drawing room discussion. पुलिस को दिल्ली आगे से मना कले अपन जानते कहबे जान कहबे हाईकोर्ट रे कहबे पे कहले से कोर्ट रे कहबे अपन केबे डकैतले अपन केबे जाइथिले कोर्ट रे कहले for time नियंतु बा नॉलेज विड्रॉ करंतु जहा अपन को चॉइस because I will record that you have not filed any such application before any court. ଆପଣ ଏଗୁଡାକ ଆପଣ କ୍ଲାଏଣ୍ଟ କୁ ପଚାରିବା କଥା କୋର୍ଟ ଆପଣଙ୍କୁ ପଚାରିକି ଖୋଳି ଖୋଳି ବାହାର କରିବା କଣ ଦରକାର ବଟ ଷ୍ଟେଟ୍ କରିବେ ଆପଣ ଯଦି ସେଟା କରିଥାନ୍ତେ ଆଟଲିଷ୍ଟ ଆଇ କୁଡ୍ ହାଭ୍ ଇସ୍ୟୁଡ୍ ଏ ଡାଇରେକ୍ସନ ଟୁ देम ଟୁ ଅବଟେନ୍ ଇନଷ୍ଟ୍ରକ୍ସନ କଣ ହେଲା ବୋଲି ମିଷ୍ଟର ଲେଙ୍କା ମତେ ଅନେଇକି ରହିଛନ୍ତି କିଛି ଆପଣ ତାଙ୍କୁ କିଛି କରିବାର ନାହିଁ ମିଷ୍ଟର ମହାନ୍ତି or ମିଷ୍ଟର ଲେଙ୍କା ମିଷ୍ଟର ଲେଙ୍କା what can be done?
Your lordship has rightly said you could have asked the court below for protection or obtain permission for video conference. Now it is
whatever that is the court's discretion.
Yes.
If the court is not exercising a discretion when requested or applied for application is made then this court as a supervising court issue direction and how can I comment that this court she feels threatened?
later approach the trial court first.
कौन कहेगा convinced
I see observation नहीं कि डिस्कस करूँगी. See, your lordship में
Mr. appearance actually बोलते Mr. D.N. Lenka AGA for the ଆପଣ होम डिपार्टमेंट कौन करछन अरे पुलिस को पार्टी करिवे ना प्रोसिक्यूटर को होम डिपार्टमेंट प्रोसिक्यूशन
state to
स्टेट डिपेंडेंट थ्रू होम डिपार्टमेंट सेक्रेटरी होम डिपार्टमेंट सी कौन प्रोसिक्यूटर से नुहंतु for the OP number 1. Kindly take your seat. Now sit down. I'll take some time to dictate. The had direct counsel for the petitioner at some length. The petitioner is the complainant in FIR number 0712 dated 11/11/2025 at Junagadh at police station Junagadh in the district of Kalahandi. It is submitted by the learned counsel for the petitioner that charge sheet has been submitted and the matter is pending trial before the court of learned additional district and sessions judge Dharmagada. It is submitted that the petitioner herself is the complainant. She has some threat perception. ଆପଣ ବେସଲେସ୍ ଆଲିଗେସନ କରୁଛନ୍ତି, ଇରେସ୍ପନ୍ସିବଲ। ପାରା 9 ଟା ଟିକେ ପଢିଲେ, ପାରା 9 page 5।
That the petitioner has a reasonable and bona fide apprehension that she will not receive a fair and impartial trial in Dharmagada due to local influence of the opposite parties and the
You are
hostility.
directly making allegation as the judge.
Oh, no, there is no allegation against the judge.
ତାର ଓଡିଆ କଣ? ତାପ ଇଂଲିଶ ବୁଝିପାରୁନାହାନ୍ତି, ଓଡିଆ କୁହନ୍ତୁ। Is it fair and impartial trial at ଧର୍ମଗଡ, ଯୋଉଟା ମୁଁ ଆପଣଙ୍କୁ କହୁଥିଲି? How can you make such sweeping statements? ଭୁବନେଶ୍ୱରରେ then indirectly you are suggesting that ଭୁବନେଶ୍ୱରରେ ଆପଣ ଚିହ୍ନା ପରିଚୟ ଅଛି ନା କଣ? Then what sort of statement you are making? ଭୁବନେଶ୍ୱରରେ ଆପଣ ପଟେ ଢଳିଯିବେ ନା କଣ? ନ୍ୟୁଟ୍ରାଲ ନୁହନ୍ତି, ଭୁବନେଶ୍ୱର ଚିହ୍ନା ପରିଚୟ ଅଛି ଆପଣଙ୍କର? Then why you are choosing Bhubaneswar? Who is that judge who will favor you? Because if you say X is unfair and no fair trial, then why will be fair? Why?
Je to accused local influence.
अरे accused role कौन होची? Accused is accused everywhere. भुवनेश्वर भी से accused हबो।
ସେ witness और ଧମଚମ କରିବ ସେଠି।
नहीं सेटा तो नहीं, सेटा छाड़ନ୍ତୁ गला। सेटा है तो record that ଆପଣ କହିଲେ କିଛି କରିନାହାନ୍ତି ବୋଲି। Don't make these statements in on oath. You are spoiling the entire thing. You are officer of the court again. If this allegation is made against you, सेठी खराब, जज खराब, पब्लिक प्रोसिक्यूटर खराब, प्रोसिक्यूशन माने इन्वेस्टिगेशन खराब, एमती कौन करा जाए सब? Perception. On being asked whether she has lodged any complaint before the court or taken recourse to law or informed the court that she is under threat, is very fair. It is fairly submitted by the Learned Counsel for the petitioner that is not the case. Stop. It is submitted that the petitioner shall approach the Learned Trial Court in case of any emergent situation, in case of any threat or any unpleasant situation.
Possible obstruction. He means obstruction. With the
से ताबी कहू नांती आज्ञा कोई आपण एते सब सुनिले से ऑब्स्ट्रक्शन वार्ड ही कहना धमक चमक चलैछन अनफेयर है ये ट्रायल धर्मगढ़ अनफेयर ट्रायल ट्रायल कोर्ट एप्रोप्रिएट अथॉरिटी कौन तापर आपनकर प्रोसेस डिफिकल्ट रिमोट लोकेशन रे अप्लाई करिवे आपण इफ द पिटिशनर अप्लाइज फॉर यूटिलाइजेशन ऑफ आईसीटी फैसिलिटी and the same is available before the learned trial court, learned DJ so and so, the learned court shall consider the said application and pass orders in accordance with law. बहुत जिनस अच्छे है। Anyway, the petition stand disposed of.
Item 6.
May I please your lordship?
Yes, please.
On behalf of my learned senior,
अपना नाम सर?
to sir Vishal Samantray.
पावर नहीं?
नहीं sir.
नहीं फाइल को जो 26 वर्षीय केस मिस्टर विशाल सामंतराय
Sir.
Mr. B. Samantray on behalf of PC Jenna for the petitioner.
Sir, kindly pass over.
Pass over the case.
Sir.
Oh, pass over Mr. Lenka notification. After recess चलियो ठीक अछि जब से आसंती आउथरे कॉल करते पे
7.
Mr. S.S. Mahapatra for the petitioner.
May I please, your lordship?
Yes, please.
My lord, in this case, the petitioner challenges the order judgment passed by the Lord Judge Family Court Puri
Yes.
in directing payment of maintenance with my lord retrospective as well as prospective, my lord. That is at page 27. That is the impugned portion of the judgment.
27.
Running page 27 and page 11 of the impugned judgment.
Yes.
Lordship's got it? My lord, that is
ଆପଣଙ୍କ ପେଜ ନମ୍ବରଟା କେତେରୁ କେତେ it is
Page lordship-
202
my lord,
ପେଜ 202 ରେ ସରୁଛି
page 202 ରେ ସରୁଛି my lord.
ଆଚ୍ଛା it's a thick one.
କିନ୍ତୁ my lord, that there is that is probably
It's a depositions and exhibits. Okay.
my lord. Page 26 is the impugned portion of the judgment.
Yes.
Lordship,
Yes.
I am submitting my lord on the factual background, my lord, that the petitioner is the husband and a wife and having
So, if
two
you-
children.
so I have made it a principle,
My lord,
not exactly here.
Yes,
also,
yes, lordship.
so
Lordship,
we have made it
lordship,
that from the date of the order till today,
Lordship.
whatever amount you pay,
lordship.
subject to the final outcome.
No, my lord, here, my lord, subject to my submission's acceptability, my lord, here it is
No,
not a
because then-
case of desertion, my lord, where,
Because before they appear and we listen to them,
yes.
we should not interfere. That is the common
No,
term of
only-
this arbitration.
Only to apprise your lordship, I am submitting the finding of the learned court below, where my lord, your lordship will find that is not, your lordship's view is correct. My lord, with regard to protection to the
Kindly
desert,
because
here it is not a case of
because the discussion will help the youngsters also. Can we see the 125?
125.
Because the adjudication is very limited.
Yes, yes, lordship.
A magistrate of the first class may, upon proof of such neglect or refusal,
Well,
this much.
here, yes, ma'am.
So even
Either neglect or my lord refusal.
only that much is to be shown to the magistrate.
Yes, ma'am.
Yes, he is not going to make further inquiry.
A lordship for a lordship satisfaction, my lord, with regard to a lordship's view in other cases. Here what happens?
Recently I have seen after grant of decree of divorce also 125 has been
Yes,
absent.
yes,
In one case,
yes,
along with the section 13 decree of divorce,
yes,
amount of 8 lakh has been deposited.
yes, ma'am.
Still the judge has passed 125 order. So that, I mean, there are cases where the facts are different. You are right there. Yes, facts could be different.
My lord, the other view of the on section 125 is that, my lord, who is not able to maintain household. My lord, that is their payment of maintenance will be there. But with regard to desertion and unable to maintain themselves, lordship kindly have a glance to the impugned portion of the judgment, page 26. My lord,
Running page 26.
running page 26. That
Internal page
is
10.
10.
Para 14.
Yes, yes, my lord. Lordship, the para starts with the OP2. OPW2 admits the cross-examination that after departure from ISKCON devotee, now other persons were occupying the ground floor of the house of the OP on rent. In cross-examination, OPW2 admitted that OP has given the house to Madhusudan Sikhanibas on rent. He admitted the OP has given his house on rent to run the liquor shop. OPW3 admitted that about running of the Bank of India in the rented house of the OP, both parties have filed their assets and liabilities. Let's say here the petitioner number 1, my lord, the wife claimed about earning of 2 lakhs per month, but she has not filed any documentary evidence to that respect. PW1 admits in cross-examination in para 13 that since 2013 years back, her marriage was confirmed.
Mahapatra, you are right. But I think that's a typographical mistake.
No, thereafter, lordship,
2 lakh admission, why suddenly this sentence?
Yes, my lord, that is
I think it's a mistake.
typographical mistake. Then, my lord,
It
it is not relevant for me. Next, my lord, I am covered. Till today, she has been residing with the OP in her matrimonial home. In her matrimonial home, the school, namely Madhusudan Sikhanibas, is functioning and rent. Admittedly, the children of the petitioner number 1 are continuing in study in the same school. PW1 further admits that the school fees both of the children is adjusted from the house rent. In cross-examination, PW14, para PW1 admitted that she, along with her children, staying in the house of OP, consisting of 2 bedrooms. Besides the tuition fee, the school of the petitioner number 2 and 3, the petitioner number 1 requests financial assistance from OP for payment of further expenditure like private tuition fees. In the circumstances, considering the affidavit and assets and liability of the petitioners are as the petitioner number 1 residing matrimonial home along with the children, and as because the tuition fee of her children has been adjusted from the house rent of OP in order to meet the other expenditures like educational expenditure, food, clothing, medicine.
Mother and two children.
2 children. They are
This is so obviously the court has taken note of the other expenditure being done by the opposite party. That 2 lakh is something pops up. It is not
that
really.
is not totally that.
So 9,000. Have they launched a execution?
No, execution has not been.
So for issuance of notice, 9,000 up to kebetu order hela.
9,000 directed from 2023.
18/10/25. 18/10/25.
My lord.
So
No, application, sorry, my lord, the application date is 11/9/2023. From that,
regarding that arrears.
Arrears. And prospectively directed.
Regarding arrears, how much total arrear?
Total arrears will be, my lord.
Kebetu kouchandi? Date?
Date 11/9/2023.
11 and 20, 24 months.
My lord.
24 months, 24 into 9.
9.
2,16,000.
କିନ୍ତୁ ସେମାନେ ରହୁଛନ୍ତି ସାଙ୍ଗେରେ ହିଁ ରହୁଛନ୍ତି.
What you do, you towards area. Now I am not directing because you are saying that they are staying and the expenditure is also borne. That's the finding. But for 9,000 for 10/11/12 January 36,000 ଆପଣ deposit କର.
ମାନେ prospectively ମୁଁ ସେଇଟା ଇଏ କରୁନି କାହିଁକି ନା ସେମାନେ ସାଙ୍ଗେରେ ହିଁ ରହୁଛନ୍ତି.
Correct.
ସାଙ୍ଗେରେ ହିଁ ରହୁଛନ୍ତି. I am maintaining.
But the problem is that if the magistrate, can the magistrate examine whether 3,000 is in, because 3,000 is a reasonable amount.
ନାଇଁ 3,000
this word
ସେମାନେ ସାଙ୍ଗେରେ ଯେତେବେଳେ ରହୁଛନ୍ତି ଏକ୍ସପେଣ୍ଡିଚର ସବୁ ଖର୍ଚ୍ଚ IMB
kindly mark the words.
ସେମାନେ ସାଙ୍ଗେରେ ରହୁଛନ୍ତି.
In order to meet the
other expenditures ମାଲଟ ସେ ତାକୁ କଲେନି ଆସେସମେଣ୍ଟ କଲେନି.
Food, clothing and medicine.
Food, clothing.
The problem is that for determination of 125, Rajneesh versus Neha is not applicable to 125.
Yes.
That is for section 25 determination of permanent alimony.
Yes.
But while discussing section 25, there will be 125.
Yes.
Section 24 maintenance parental right. Also, other provisions like domestic violence.
It also can be settled
in domestic violence act. So those proceedings are not definitely are not there.
Yes.
Maybe is there any separation section 13?
No. That has not been. There is every
possibility. Hopefully things will improve. So you deposit 9,000 for 4 months, 36,000 and arrears after they appear. Your point that they are staying and their fees, school education is taken care of is well taken. The court has noted that.
Only one kitchen, both are husband wife.
Because this to form an opinion on that, let them appear.
May I pray one thing?
Yes,
I think it can be settled. My lord, because
let them
there
appear.
is
Let this amount be deposited to the credit of either directly account or deposit correct direction.
नहीं से क्वेश्चन तांको पेमेंट करी वाला कि लॉर्डशिप may I do one thing? May I deposit before the registry of the whatever lordship will direct. But one thing, my lord, may I request and pray, my lord, there is every possibility for their, my lord, settlement. Let them be directed to appear before the.
Let them appear first.
Yes.
In most of the cases, the women are not appearing because they know it is of no use.
Yes.
Because their maintenance is not paid. Coming to court, they have some hesitation. And spending money for litigation, they have further hesitation. So in most of the cases, they are not appearing. And if you pay that much of amount,
yes.
now you have, that's the point. So at least they will be assured that something they have received due to the court's order. Because by approaching the court,
No, that goes
they have spent some money.
in other way, my lord. They are being the wife is being guided by her brother for that creating nuisance. Many our affairs has been lost by the tenants against that wife and the brother, my lord. They have created nuisance here. For that, everything has been disturbed. On their appearance, it can be settled. Well, it is the
Let us know, first of all, they will appear.
Yes, my lord. Lordship may pray one thing, my lord. With regard to family structure, they have also lost one affair against the petitioner with regard to 498 and the tenants have lost the affair against the wife and the wife lost the affair against the petitioner. Well, these are the situation there. Lordship may direct the IAC of local police station to cause an inquiry.
Not without hearing them.
Lordship.
By unilaterally hearing and believing everything,
and that
the whole proceeding looks very odd.
The law and
Let
court
them appear. Let them appear. You have to be patient there.
Law and court below didn't consider the entire expenditure he had submitted before the law and court below. That has been exhibited. The loan accounts, everything. Only
Since you have made out a case that they are staying in same place, but let them appear.
May pray, my lord. Due to financial stringency of that person, 20,000 you will deposit.
No,
without prejudice.
No, it has to be uniform.
Yes.
Only thing I'll to that extent I'll direct that it will deposit in the court.
To deposit here. That's it.
Appearance defense. The petitioner, you just take your seat. Yes. The petitioner husband is before this court, challenging the judgment dated 18/10/2025 passed by the learned judge, Family Court, Puri, in CRP number 98 of 2023. CRP case lecture. CRP case number 98 of 2023. By the said judgment, the petition filed by the opposite party, wife in the marriage, and two minor daughters born from the wedlock, represented through their mother, opposite party petitioner. 125 provision election under section 125 CRPC into bracket since repealed, comma, seeking maintenance of rupees 40,000 per month was allowed. However, directing maintenance amount of rupees 3,000 for each of the petitioners, making the total of rupees 9,000 per month. The learned counsel for the petitioner refers to the paragraph 14 of the judgment to submit that the learned court had noted that the opposite party petitioner as well as the children from the marriage are staying in the house of the opposite party. The tuition fees of the study expenses. The study expenses of both the children are borne by the petitioner husband. ଆପଣଙ୍କର 3000 for area, 4000 for future.
my lord.
तो ऊपर लिखे 3000 ସେଟା 4000 କରିଦେବେ। ଚାରି 12 ହବ ତାହେଲେ 4000 per month ତାହେଲେ 12000 ହେଲା making 12000 per month. But it is further submitted that though there is a dissension between the party, OP number 1, wife and the petitioner husband, but there is every likelihood of settlement between the parties. Issue notice along with this order, subject to the petitioner depositing rupees 12 into 3, like 36,000 for the maintenance directed from the date of order, that is 18/10/2025, for the months of October, November, December 2025 and January 2026. बात रही 3600 कितने ये for the month of October, November, March, November, December, January of November and December 2025 and January 2026. बात रही 36. The deposit shall be made before this court by demand draft favoring the learned registered judicial to be kept to the credit of, to be kept in a high interest yielding fixed deposit in a nationalized bank with auto renewal clause, to be kept to the credit of the present petition. How much time you will require, Mr. Mahapatra?
Lordship, 10 days time.
The deposit shall be made within 10 working days. Thereafter, the requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 5 working days. So, upon making of the deposit and filing of requisites, notices shall be issued to the OP number 1, also representing OP number 2 and 3. This after SR liberty to mention. IA number 623 of 2026. Had learned counsel for the petitioner issue notice as above, accept one set of process fee and postal requisites. List after SR liberty to mention. Yes, next.
Madam, I
But, there may be stay operation of that.
No, since there is no execution,
My lord.
so that is why I've given you liberty to mention. Yes, no difficulty. Well, let us see. They execute, then you come again. Anytime you can mention.
Obliged.
Yes.
May I please your lordships? I am in VC, my lord.
Yes. Why you are not coming to court physically? Yes.
My lord, because I am suffering from my lord.
Nityendu Sundar Rai for the petitioner.
I may be, I'm allowed to in physical mode, my lord, day after tomorrow, my lord, because I am suffering from some leg injury, my lord.
No, you please submit. You please submit.
My lord, my lord, my lord. My lord, in this case, my lord, the petitioner has challenged the order dated 14/12/2024, passed in the National Lok Adalat Balasore, my lord. By
Mr.
NS
Sundara,
Tribunal.
you first examine the judgments of the Honorable Apex Court on this.
Yes, my lord.
When the Superior Court can interfere in Lok Adalat, because you have signed, you have agreed.
Yes.
So you examine that,
my
then you
lord.
address.
I have not agreed. Behind my back, this order has been passed, my lord.
Sir, then how the appellate court will interfere? That is the first ground I should not entertain.
My lord, there is a...
Sir, if you do not listen, it will not register.
My lord, yes, my lord.
How this appellate court will give a finding that this was passed behind the back of somebody? This is only the same court which has passed the order. This cause has to be urged before the same court which has passed the order and will decide whether it is behind. It will recall the order.
My lord.
How the appellate court will interfere?
My lord, there is a decision of this honorable apex court, my lord.
ଆପଣ ଶୁଣିବେନି, that's the problem. ଆପଣଙ୍କୁ ପଚରା କଣ ହେଲା ଯେ decision ହେଲା ଆପଣ କଣ ଚେଗଲ ଭେରିଆ ନାଇଡୁ?
My lord, no, that is Bhargavi Constructions and another.
ସେଟା ସେ point ରେ ନୁହଁ. Bhargavi Construction is not the same point, on that point.
My lord, it is
maintainable. The problem is that you are telling the appellate court that the decree has been the settlement before Lok Adalat has been obtained behind your back. How this court will adjudicate that? When did you move then the next question, when did you move the court and the court has rejected your plea?
My lord, because my lord,
you cannot jump around. Every time something happens, you leave the court and come to another court. Then what the other court will do? How I will form that opinion?
My lord, I have the impression that REIT is maintainable against the order of National Lok Adalat, my lord, on the basis
Sir, your impression is wrong. Your impression is wrong. Second, the blunder is that the plea that you are taking, which you should have taken before the trial court, you are taking for the first time before the appellate court.
My lord, this is not the trial court, on the basis of the compromise between the two parties, that is...
Sir, you are telling me, I follow English. I have been asking you, because you understand English, I have been asking you in both English and Odia, that when did you file this application for recall of the order passed by the Lok Adalat, that which was obtained by committing fraud on the court?
Yes, my lord, because I have not got the opportunity to file, because I have the impression that I have to file.
Sir, who gave you the opportunity? How could you get the opportunity to come to the High Court?
My lord, on the basis...
The same opportunity is available before the trial court.
My lord, may I be permitted to, my lord, that read the judgment of this, my lord?
Sir, first you find a judgment favoring you. The judgment which is against you, don't cite those judgments.
My lord,
always try to read the judgment. Give the citation.
My lord, 2017, my lord, SAR Civil 1058.
Don't give those unknown citations. Give a AIR, SEC, Supreme Today, or Indian National Supreme Court, INSC.
Or day after tomorrow, my lord, I will...
The problem is that now this is the AI, unable to understand it, it is picking up from the moot court competitions. That is most like the reasons they're saying. Actually, it is not fabricated, it's a mistake by the AI. Do some effort, do some research. You can do it. And also please examine those judgments, whether the plea that it was obtained behind your back should be taken for the first time before the appellate court. And on your own showing, you are not saying before this court that yes, I moved the court, but the court did not entertain me.
Well, this is not...
You are taking a strange plea that I didn't have an opportunity. You are, in one hand, you are saying that it is behind your back. So no opportunity can be given to you. Who will give you the opportunity?
Because the order has been passed by the Lok Adalat, my lord.
Sir, by
the basis of the compromise, my lord. This is not passed in a merit, my lord, by the appellate court, my lord.
Hearing me, sir. When did you tell the Lok Adalat that I have not given consent? By which petition? Which is the annexer?
I came to know about the mischief.
Sir, after coming to know about the mischief, laid against you. When did you approach the court? By which petition? Where is that?
No, I have not, my lord. I have not filed any
Who
petition, my lord.
Who will do that?
My lord, because I
Who
have that.
will do that? Because who is under obligation other than the person who is grieving to bring to the court's notice? Who will do that?
The present petitioner will, my lord.
Oh, then why you are going on? This has been passed by the Lok Adalat. Sir, it is a trial court. Definitely, it is not a Lok Adalat. It's a trial court. It may not have conducted a trial. Since I have to tell the court to be a trial court. Don't take exception to that. There you are wrong also.
My lord,
This court, that particular order was passed because a proceeding was pending before the trial court. It went to the Lok Adalat. Then it happened. Or maybe a permanent continuous Lok Adalat. There is a dispute. Yes. Which citation you are giving?
My lord, that is 2017 SAR civil.
সেটা কোনটুনি SAR কোনটুনি পার্টি নাটা কোনটু
আগে ভারভাগী constructions and another.
স্পেলিং কোনটু ভার্গবী?
BHARVH. My lord, may I pray, my lord? Day after tomorrow, I will.
Day after tomorrow, and also you come with the petition filed before the Lok Adalat, and what is the response of the Lok Adalat? Order on that.
My lord, petition, my lord, within 1 day, my lord.
After coming to know of this fraud committed on the petitioner slept over it to reach High Court or approach the court. That is the question you have to answer.
My lord, I have the.
Nobody else is under duty to search for the petitioner.
My lord, because my lord, the writ is maintainable because my lord, against the order of the.
Sir, writ is maintainable, but the writ has to be considered, or because you have Mr. So and so is appearing, I will allow everything. You will not answer whether you have approached the court. The petitioner had direct counsel for the petitioner being present in VC addresses arguments. It is submitted that order impugned before this court dated in the writ application dated 14/12/2024, passed in MSC number 110 of 2024. Decided in the National Lok Adalat, Court National Lok Adalat 2024 by the Court of the District Judge -com-MSCT-1 Balasore. Was result of a situation where ଆପଣ ସେଥିରେ କଣ ଥିଲେ MSC ରେ?
MSC ରେ ଆଜ୍ଞା କିଛି ନଥିଲୁ ଆମେ ତ ଫାଇଲ କରିପାରନୁ ଆଜ୍ଞା
କଣ ଆପଣଙ୍କର ଲେଗ ଇଞ୍ଜୁରି ପରେ କଣ ଅସୁବିଧା କଣ ହେଲା? ଆପଣ ପିଟିସନର ଥିଲେ ରେସ୍ପଣ୍ଡେଣ୍ଟ ଥିଲେ କିଏ କହିବେ ଏଗୁଡାକ?
ମାନେ ମୁଁ ଆଜ୍ଞା ସେଥିରେ ପାର୍ଟି ମତେ କରାଯାଇନି ଟୋଟାଲି। ଆଇ ଏମ୍ ଦି ଓନ୍ଲି ଲିଗାଲ
ସେଟା ମୁଁ ଆପଣଙ୍କର ମାନେ ପଚାରିବି ଆଇ ଗୋ ପ୍ରୋଭିଂ ଏନକ୍ୱାରି
sorry my lord I am
so sorry, I don't understand. I'm really sorry that you are so sorry, but I have to ask you everything. Why should you be sorry? You are not a party in that case. You are challenging. That should be your first statement. कौन लेकिन last line करो. The petitioner was not aware of any such proceeding. On being further asked whether the petitioner was represented before the District Judge -MSCT-1 Balasore in MSC case number 110 of 2024, they submitted that the petitioner was not a party in the said proceeding. ଆପଣ ପାର୍ଟି ହେଇଥିଲେ କଣ ହେଇଥାନ୍ତେ ସେଠି? ପିଟିସନର ନା ରେସ୍ପଣ୍ଡେଣ୍ଟ ହେଇଥାନ୍ତେ?
ଆଜ୍ଞା ମୁଁ ପିଟିସନର ହେଇଥାନ୍ତି। ଆଇ ଏମ୍ ଦି ଓନ୍ଲି ନେସେସରି ପାର୍ଟି ମାଇ ଲର୍ଡ, ଦେ ଆର୍ ନଟ୍ ଦି ପାର୍ଟି।
ଟିକେ ରୁହନ୍ତୁ ଆଜ୍ଞା, ବହୁତ କଣ ଲେଖିଲେ? Proceeding either as a petitioner or as a respondent. nor as intervener. Para. It was further asked to the learned counsel for the petitioner whether the petitioner, before coming to this court challenging the said order dated 14/12/2024, in any manner had approached the said court, that is district judge -MSCT-1 Balasore. The answer is no. BHA Bhargavi, BHARG, the V.
VHAR VAGI.
अरे एमपी कौन तो एटीके पॉज नहीं कौन तो है फास्ट लेटर कौन बी ना V?
B my lord, B
then H
my lord,
तापरे AR तापरे
VAGI.
BHARV.
V.
Then how it is Bhargavi?
Bhargavi GI.
ଆପଣ ସେଥିରେ ବି ପାଟି ନାହାନ୍ତି ତ ପଢି ନାହାନ୍ତି
ଆଜ୍ଞା
ଆପଣ ଜି କୁ ଭି କହିଲେଣି ଆପଣଙ୍କର କଣ ଗୋଟେ ହେଇଛି ଆଜି ଆଉ
Bhargavi Constructions and another versus Kotha Kapu Muthayam Reddy.
ସାଇଟେସନ ଲେଖନ୍ତୁ ସେଟା ବି ଜଜ ଆପଣଙ୍କୁ ଆସିଷ୍ଟ କରିବେ ଲେଖନ୍ତୁ ଆଜ୍ଞା 2018
ପାଇଲଟ
କୋଥା କପୁ ଉପରେ କଣ ଅଛି
ଆଜ୍ଞା କଥା ପାକୁ ମୁଥୟମ ରେଡ୍ଡି
into bracket 2018 13 SCC 480 para 33 पढ़ो
that judgment I am referring, my lord.
आज्ञा
The defendants on being served with the notice of the suit.
मैच करूनी ଆପଣ ଗୋଟେ କୋଉଠୁ ଆଣିଛନ୍ତି ସେ କଣ ତାର so far as the second submission पढ़ो last आड़ को जानतु पूरा
आज्ञा
लास्ट पारा पढ़ो कौन लिखा है
with however make it, my lord, clear.
ता पूर्वटा
As a result the appeal succeeds in the light of foregoing discussion.
yes ता पूर्वटा पढ़ो
para 37, my lord.
थरे परा कहली एटा एससीसी रे मैच करूनी आपण गोटे 33 सेटा so far as second submission पढ़ू ना दी कहीं
ठीक है, my lord.
अरे आपण कोन खोजछोंती
कोटा टिके लास्ट
आपण जे पढ़ू नै दे म आपण कहली पढ़ंतु बोली तापर आपण अगेन आउट कोन कहबा आरंभ करू
in the light
discussion कहलो
in the light of foregoing discussion.
ता पूर्व पाराटा पढ़ंतु so far as देखंतु कोठे अछि जस्ट कैपिटल लाइन छाड़ दियंतु ता पूर्व पांचटा लाइन पढ़ो
so far as the second submission of the learned counsel for the respondents is concerned, it also has no merit in our view. The decision rendered in the case of state of Punjab Supra
in the case of लिखा है in state of Punjab,
my lord, state of Punjab, my lord.
my lord कौन से लिखा my lord किस लिखा है आपण कोन ऐड करछो सेति पे डाउट होछ is by the larger
is by the larger bench and is therefore binding on us. No efforts were made and rightly to contend that the said decision needs reconsideration on the basis on the issue in question. That apart, when this court has laid down a particular remedy to follow for challenging the award of
when this court has laid down a particular remedy to follow
for challenging the award of Lok Adalat, then in our view, the same is required to be followed by the litigant in letter and spirit as provided therein for adjudication of his grievance in the first instance.
That was the question posed to you. So you have to show this. Supreme Court has said that whatever has been laid down by the Supreme Court to challenge the order in Lok Adalat, you have to follow in letter and spirit. So that is how I said that this judgment, when you are citing, be careful in reading that.
Yes, my lord.
So kindly follow that, whatever the Supreme Court has said, because you can't, because there is a difficulty in the whole process. In MSCT matters, there is involvement of so many judges, so many litigants, so many parties. It can't be easily overthrown. And if you apply Bhargavi construction 33, that when this court has laid down a particular remedy to follow for challenging the award of Lok Adalat, the same is required to be followed by the litigant in letter and spirit. You read and then you come back. You are going on saying that read is maintainable, when it was asked to you that it is not maintainable. So read that again and read the earlier judgment, State of Punjab.
My lord, 2018 7 SCC, my lord.
13 এই সাইটেশন কথা কହୁଛନ୍ତି
sir, the previous judgment jota sir କହିଲେ
ସବୁଗୁଡାକ ପଢିବେ ଆପଣ ଏମ୍ ଲାଗୁଛି ବି ପଢିବାକୁ ପଡିବ
ଆଜ୍ଞା ମୁଁ କହୁଛି my respective submission please to issue notice, my lord, then
no most respectfully I cannot issue notice passing illegal orders. I need to have some semblance of law involved in my orders.
My lord, fraud is committed by
that you see, you are not a party even.
Because they have not made party, my lord. Fraudulent they have taken.
So for that, so you have to check the law, that how you will, a litigant will follow letter and spirit. Because Bhargavi now is a headache for you after citing Bhargavi. You overcome Bhargavi fast. Or you can read and reread para 30, what you have read just now. What is your paragraph?
But that is, we however make it clear that the respondents would be at liberty to challenge the legality, correctness. Paragraph 37, my lord.
So 37 then you will address what you need to do. It is, this is not a, courts are not sitting here for issuing notice and passing orders contrary to Supreme Court decisions or provision of law.
My lord, fraud is committed, my lord, has committed, my lord, is there.
So who is saying fraud is not committed, sir? You don't have to seek relief that when I say fraud is committed, fraud is committed. You have to do something to do justice to your client.
They have taken
and
money,
doing justice to your client is not a method of illegality. So you are committing fraud on Supreme Court decision, fraud on High Court. Your client is doing by requesting such, making such request. Should it be? One fraud will be undone by another fraud. You must understand what you are arguing in court. That since fraud is committed, pass orders without referring to law, without any following any provision. What is the provision of setting aside ex parte decree?
Recalling of the order, my lord.
Then that also I have to assist you. I have to give you the citation, paragraph. You will only one mantra. Fraud is committed, fraud is committed. Even you do not say that I am not a party. You can go to the extent of arguing that when you are not a party, it is not binding on you before the court for recalling that order. This is not the way, sir. This is not the way that, with greatest of respect, that courts will deal with this problem. Somebody comes and says that fraud is committed, issue notice. How can it be, sir? Then why the Supreme Court just read that you have missed the second line? Para 37 the last line ta padhuntu ta pare.
May I read, my lord?
I am requesting you to read. It is up to you whether you read or not.
But that apart, when the court has laid down a particular remedy to follow for challenging the award of Lok Adalat, then in our view the same is required to be followed by the litigant in letter and spirit as provided therein for adjudication of his grievance in the first instance, the reason being that it is a view of the land under Article 141 of the Constitution of India, M. Nagaraj and others versus Union of India and others, 2006, 8 SCC 212, it is then for the writ court to decide so to what orders need to be passed on the facts arising in the case.
Now you got it now. So that is what I wanted to, humbly I will request you that you reflect on this. Even let's say injunction on the writ court also. Unless you follow whatever has been laid down by the court, it is a 141, it is by the law of the land. Writ court hands are tied also. That you must understand. But thanks for your time and discussion. That's at least I as a student of law have benefited from with this discussion. Yes. When do you want? Yes. The Learned Counsel for the petitioner relies on the decision of the Honorable Supreme Court rendered in Vargavi. But lecture citation ta purada de debe hai na. Difficult na that is Kotha Vargavi Constructions versus Kotha Kapu Mutham Reddy. Likhi de. Into bracket 2018 bracket close 13 SCC 480. Paragraph 33 of the said judgment is reproduced herein. 33 ta reproduce kar den. The Learned Counsel for the petitioner has adjournment to obtain instruction and address whether, as directed by the Honorable Supreme Court in Vargavi Constructions, Supra, referring to the earlier decisions of the Supreme Court, that the present litigant has followed the procedure laid down by the Apex Court for challenging the award of Lok Adalat, and the said remedy has been followed in letter and spirit for adjudication of his grievance in the first instance. It is a paragraph language that reproduce for the last. Yes, Mr. Ray, when do you want?
My lord, 1 week time, my lord.
Lists out of the same list for fresh as adjournment लिखे था concluding paragraph. The matter shall be listed for fresh admission in the week commencing 9 2 ना फर्दर टाइम
ना 9 2 वाला
9 2 2026 9 2 ठीक अछि तो
my lord, your lordship may please my humble submission issue notice.
Sir, I have been equally humble, sir. There is a competing humbleness between us. But there is some law, Article 141 Supreme Court. We have to humbly bow down to those directions. And to my understanding as a student of law, it is correct also.
They will siphoning all the amount, my lord. They are not legal heirs, my lord.
For siphoning of amount, you have a different remedy. Not read court. Even they invest the money, so still you can recover it.
Lady, my lord, Pardhan lady, how will recover, my lord? Only child, my lord.
Sir, the illegality cannot be answered with illegality. Please appreciate that also. I told you that. We can compete in humility, but not illegality.
Your lordship has ample power, my lord. Vast
No.
power, my lord.
Ample power to do illegality? No, never. That is not my oath, sir. So powerful that I'll pass illegal orders contrary to Supreme Court decisions. And that is how I have made the effort, so that you also realize that in what course you have adopted, the petitioner has adopted. Yes, next.
Item 9.
Yes, yes.
Simple prayer made before this honorable court. A direction may kindly be issued to the learned judge, family court Khurda, to dispose of the case within a preferable period of time.
Which Supreme Court decision gives that power? Like Mr. Sundar has really elevated me to all powerful, almighty. I can pass orders.
No, I am not citing any.
So there are contrary Supreme Court decisions that court discriminating other cases. Your case cannot be expedited.
On earlier occasion, this honorable court remanded the matter, and in that case, it was specifically directed to conclude the trial as far as expeditiously as possible without giving any unnecessary adjournment to either parties. And after producing of that judgment, again the trial was commenced, and the petitioner, who is the petitioner, he is also the petitioner in that court in the CP 278. In each and every date he appeared, and already three witnesses were examined, but the opposite party is not giving her evidence affidavit and taking time. And during
I'll transfer that petition to this High Court.
No. Only my simple.
So you have to move that court, citing the Supreme Court decision, High Court decision, that he is taking time, not giving her evidence, pass orders. Which provision in CPC?
That is also in 21B of Hindu Marriage Act. That is also
I cannot
6 months.
So you file that application. So after you file that application, the court is not responding, nothing is happening. Then I have 227 power, not Mr. Sundarai power. That I can do anything.
Already order passed.
So that is right for that court. So who am I? I am not implementing court for the earlier order passed.
Earlier by this order,
you have to use that to your advantage, not for filing another writ application. If the learned court is not veering off track, suppose, let us assume there is a court order and the court is not abiding. So you file that petition before that court. Let the court handle it. Unwittingly what you are doing, you understand. You are saying that the first writ court's direction, High Court direction, the court is not following. The second order should be passed. That itself is contradictory. Mr. Mishra.
The case is of 2007.
So that is how this penalty increases.
9 years 9 years of litigation.
Definitely, sir. 9 years for a matrimonial cause is very usual for our system. 19 is usual, how 9 is unusual.
3 times, 4 times is taking time for cross-examination.
Please file that application, sir. I can't call her to say that why you are not appearing, obeying the High Court order. That petition, who is to file?
That has been made already.
So file that. So that where you have annexed. Show me that petition, what order has been passed on that. No difficulty. When you have filed that petition regarding compliance of the order, following of the order, not exactly compliance, because of that, as expeditiously as possible. So where is that petition before the trial court?
That order sheet itself reflects that after
your petition, sir. When you file that
oral request was made to comply the order of this.
I do not talk with lower court judges.
Oral request was.
I only go by their orders.
Repeatedly oral submission was made before.
Oral will be better or I cannot say. That is your choice. Whether it should be repeated oral or one line, one petition, that is your choice. And the High Court judge cannot talk over phone that I will also pass oral orders. You have to bring something before us. Me at least. That cannot be. At the cost of other pending litigations, I cannot. When that is prohibited by the Supreme Court.
With that liberty, in that light. This petition came.
Mr. Pratap Chandra Mishra for the petitioner. Mr. The state is not opposite party blank. The petitioner, this was remanded after MATA or
In MATA.
then how it is 9 years?
Please.
How it is 9 years?
The case is instituted.
You are also saying that High Court took it, High Court took 9 years.
No, no, no. 17 ମୁଁ କହିଲି 17 ମସିହାରେ case institutional.
Then you can take the marriage date also. The cause of action was the marriage date or the negotiation.
9
date.
ବର୍ଷ ହେଲା କାଲିଠୁ ସେ
So that's a wrong fact I will state. Don't make me to make my orders vulnerable. If it is remand order is how, what is the date of remand?
remand 10/7/2024.
So 10/7 is 6 months. I will now I would have dictated 9 years.
ନା ନା 24
Just I was going to dictate.
10/7/24 ରେ ଅର୍ଡର ଯାଇଥିଲା ଇଏ କରିବା ଲାଗି।
10/7/24 ହେଲେ ଆପଣଙ୍କର ହଉଛି 19 ମାସ 12/7/19 19 ମାସ ମୁଁ just now I was dictating 9 I was able to dictate 9.
କେସ୍ ଟା ଇନଷ୍ଟିଟ୍ୟୁସନ ହେଇଥିଲା 9 ବର୍ଷ
How does it matter if the Supreme Court demands what you will tell?
ହେଲା।
If the case is remanded without any further trial, that's a different thing. Though it's an open demand for further trial, then I will dictate 9 years. The judge cannot say anything.
Yes,
the family judge, she will only laugh at me. One High Court judge, 2 judges have sent it by the remand. Another single judge now saying that it is pending since 9 years.
Minus.
Anyway, only clear? Apparently clear. Just take your seat. I'll take some time in dictating.
Published.
Yes. The same CP number is there, or it has been again
No, same CP.
Same CP.
Same CP. 208 of 2017.
The reason is different, Mr. Mishra. I have been telling this. We are very lenient to our brothers at bar because we take time, they take time. You never file a petition for taking about that, but I mean asking the court to pass an order because where you take time, I mean your learned colleague is lenient towards you. When he takes time, you are also lenient. So you rarely find that there is elaborate provision in CPC that when so and so appears, so and so doesn't appear. When so and so appears, what would happen? These amendments have been brought in 2002, 2001, those. But why it is not happening? The reason being that we are, as members of the bar, I belong to that side also. I was there. So we are lenient because we consider maybe there is a personal request also. But if you file a petition, you will see the result. It becomes almost impossible for the court to adjourn the matter. And court's hands are full, largely. You'll having three family court judges in for the Bhubaneswar, still inadequate. Lot of pendency. And some matters like since 2017, now after remand again pending. That adds on to the, even after disposal also, it comes to appeal. So there we are not hiding those petitions. We have to file those petitions. It is high time we have to think whether professionally, yes, you will maintaining a cordial relationship. But you should have filed this petition. Or like that. The petitioner husband in the marriage is before this court, seeking early disposal of the CP number 208 of 2017. Stop. The said CP was filed by the petitioner husband under Section 13, at Section 13 of the Hindu Marriage Act. You take your seat. Take some. Section 13 of the Hindu Marriage Act, seeking dissolution of the marriage with the opposite party wife. Earlier, stop earlier MATA was MATA 59 of 2023. MATA was filed at the instance of the wife or husband?
Husband.
Was filed by the petitioner. challenging the judgment in the said CP. Emitted a number which? Yes. Stop. By judgment dated 10/7, by order dated 10/7/2024, the MATA was allowed. The matter was remanded to be considered afresh by the learned judge family court. Para. Is submitted by the learned counsel for the petitioner that since the initiation of the proceeding in 2017, already 9 years have passed. Stop. Is further submitted that the opposite party wife is taking into court unnecessary adjournments, hotels. Part. They submitted that the petitioner has completed his evidence. Or sure gal bhul wale jo fere.
Na, I'm sorry.
See who avde fail kariye aigya bhul pa petition
No,
file
no.
kartile.
It's on the side, evidence is closed.
The petitioner has completed his evidence, but the opposite party wife in the marriage is taking time. It is submitted that the division bench of this court in disposing of the MATA had directed for disposal of the city, as expeditiously as possible. Stop. On being asked whether the petitioner had filed any application before the learned court in season, indicating that the opposite party is taking unnecessary time. Unnecessary adjournment. And if so, what is the order passed therein? The learned counsel for the petitioner upon instruction submits that there is no such application. Stop. In considered view of this court, at the instance of a particular litigant, a CP cannot be expedited when thousands of cases are pending before the self-same court. So, however, if the petitioner moves the learned court in session of the matter for any appropriate order in accordance with the provisions of the Code of Civil Procedure as well as the Family Courts Act, the same shall be considered and necessary orders shall be passed in accordance with law. Also keeping in view the earlier order passed by the division bench for expeditious disposal of the CP. The petition is disposed of accordingly. Yes, next please. जोड़ा अर्जुन इस कॉल करो टाइम सेव करिवा ना
Item 11,
May I please?
Yes, please.
Lord, this IA has been filed, my lords. Enclosing the letter of the ESI corporation matter is pending before.
Can you speak to the microphone?
Again?
The microphone. So words I'm missing.
I'm Lord, sir. While the matter was pending before this honorable court, my lords,
Yes.
the ESI corporation has given a letter to the petitioner to avail the amnesty scheme, my lords.
Yes, yes. You said that they are doing it,
Yeah.
but due to pendency, it is not being carried out.
Only your lord.
One of the condition that the petitioner is required to take permission of from this honorable court to settle the matter out of court.
Yes.
Permission কেমতি দিয়া হবে?
না সেটা
No provision again.
না
Again, we are bar. So it is always open for the parties, sir.
Yes.
open for the
Even,
parties.
sir, even in criminal case, there are compoundable offenses. Apart from the compounding provision ଅଛି, then fair enough. We have no difficulty in, observing that.
No
But if you
objection.
say we will permit, then I think we are not resisting anything. Language কথা বলবো।
Sorry.
So why should be sorry, sir? Again, any discussion, ଆପଣ sorry କହିବେ।
One of the condition যে pending ଅଛି, you should take permission. Then
So this matter will be kept pending na nahi, it dispose of it?
kept pending.
Kept pending. My lords, your lordship may
Subject, during pendency you want,
Yes.
that is another aspect also.
My lord, your lordship may kindly see paragraph 3 of my IA. In all the cases that it is prayer, my lords.
IA 1581.
Yes. Only small affidavit, not.
2 and 3, sir.
Two and two the letter. Yes.
IA copy, sir.
Man.
Sub.
It will read petition WPC with IA 1581 of 2026, flat D range. The IA has been filed by the petitioner, copy of which has been served on the learned counsel appearing for the opposite party, Mr. Ray.
Man.
Appearance declaration, Mr. Somnath Misra for the petitioner, Mr. AP Ray, RA Wiley, Amarendra Prasad Ray for the OP number, for all the opposite parties,
Man.
for the opposite parties. I has been filed by the petitioner. Sir. Prayer in the IA is for granting leave to the parties to avail the benefit of the amnesty scheme during pendency of the writ application. Annexed to the IA, the amnesty scheme is an amnesty scheme dated 12/1/26. 12/1/2026, which is scanned and reproduced here. The learned counsel for the opposite party endorses the submissions made at the bar by the learned counsel for the petitioner. Stop. Also brings to the notice of this court that the parties, as for clause quota quotient,
My lord.
Kuja lekha hai ki? छाड़ दियो दो कौन लिखे एक्सीडेंट काट दियो is endorsed by the learned counsel for the opposite party, in view of the above, it is expected that the parties shall work out a
Amicable.
Work out what, sir? कौन को आजीबो?
Amicable settlement of
Under the scheme.
Amicable settlement as per the amnesty scheme, acceptable to both the parties. And this court in no uncertain terms encourages such settlement in view of the amnesty scheme dated 12/1/2026. The IA is allowed, IA is favored and disposed of. The parties shall work on the amnesty scheme 12/1/2026 and arrive at a settlement.
Same order may be passed in all.
Read will be pending, my lords.
Read during pendency.
Again.
The read alga order करते the read petition no add करते read petition shall be listed after.
ସେଟା କେତେ ଦିନ ଲାଗିବ ନାଇଁ ସାର୍ ସେଥିପାଇଁ ମୁଁ କହୁଥିଲି ଆପଣ କରିଥାନ୍ତେ ଯେ pendency of the writ application shall not be ସେଇଟା କରିଦେଲେ
pendency of the
writ
application
shall not be
a bar in any manner whatsoever
for the parties
for the parties to work out
yes my lord
amicable settlement in terms of
the amnesty scheme again ସେତିକି କରିଦେଲେ all these matters are sir
the writ application shall be listed after 6-8
sir ଆସୁ ସେ କେତେ ଦିନ ନେବେ ଆମେ ଜାଣିନୁ ନା
8 weeks ପରେ
ଆଜ୍ଞା 8 weeks he will submit
8 weeks ପରେ date କरो
ଆଜ୍ଞା
ମାନେ ଏପ୍ରିଲ ମାର୍ଚ୍ଚ ଲାଷ୍ଟ କି ଏପ୍ରିଲ କି ପଳେଇବେ
ହଁ ଏପ୍ରିଲ କର 6 interim
in the week commencing 6/4/2026
ଆଜ୍ଞା
liberty to mention it is further clarified that so the election pendency जो लिखिले तो line out add करिवे the interim order passed earlier
sir
shall also not hamper the working out of a settlement
and that will continue also
shall continue the interim order passed earlier shall continue however it shall not in any manner come in the way of the parties to arrive at amicable settlement
sir it's same order in all the
connected matters
again
my lord
Mr. Somnath Mishra
again खाली I item change हबो एतिकी
I number has to be very
again sir आउ गोटे रही है काल can it come tomorrow my lords
ठीक अछि एटा काली आनिबे ना दीटा आनिबे
दीटा आनिबे great
दीटा
आगे he is my land friend is perhaps there
ओडिसा है ना
हां नहीं ओडिसा नहीं कलिंग कंट्री आपण अछि
हां कलिंग कंट्री मतलब तो कॉपी तो दे
हम दे
कोटे एक्स्ट्रा कॉपी में दे देबो
sir another difficulty has sir one matter my lord justice S Mishra was hearing so he after seeing the record my lord he said I am concerned sir se suniben now honorable chief justice has directed Mr. VP Satpathy to hear the matter but in the meantime assignment has changed and my lords is in the session of the matter so can it come my lords to your lord
not as per my order
so again you have to move this honorable
I think now you have to move the deputy registrar
I'll take
because the standing order is to be assigned bench so upon it has to be placed in the administrative side
sir
for remarking in that sense because he is the master of the roster
yes sir
but your point is correct and it is now notified that if the assigned bench is available it will go to the assigned bench
sir that will be better because there's
the recusing bench is now no more available another bench is available that is your submission
sir
so kindly move the deputy registrar
yes sir
and if you can file a joint memo also you can take his signature for this
better also say Orissa instrument
तो असाइन बेंच रे से मूव करिवे तबे आपण जॉइन मेमो कर
हां मु आज
देखो यदि एटा फाइल टाइम मिलिबो आपण रहिबे ना जिबे
सर मु अछि
मिस्टर रे
अछि
ताले ठीक अछि देखो नॉमिनली इन्फॉर्म करिवे मरु देबे काली आनिबो
आगे
rest of the matters wherever you want adjournments he will give you and please both of you agree otherwise in absence of the other side it becomes difficult
item 20
ठीक अछि सर जोड़ा का टेक अप होबो आफ्टर रिसेस जोड़ा का सिंपली adjourn करिवे like in the morning also you can adjourn he will give you the dates no difficulty I trust all of you yes rather I have to trust all of you
difficulty I have not appeared
appearance note करिया कि चाहछु
my lord
तल तो ऑर्डर करिया दरकार आपण को कोली को कहि दियो केबे फाइल कले ओकलत नामा बा केबे कोन अपीयरेंस देला सेटा दे देले सेटा ऑर्डर करिया पड़े This is correct. Correct.
Yes.
Both of you. I'll pass that. I'll simply say that the matter was not listed, but in view of the batch of matters listed involving similar issue, Item 11, who is for the state? No, state.
No, no,
is not
state-
the party.
it is not a part.
Okay.
Similar order may be passed,
Correct.
keeping pending the writ petition.
Yes, yes.
Obliged.
But writ application should have been disposed of with liberty to revive.
Yes,
The
sir.
reason being, I don't know, they may be little bit apprehensive during pendency of the writ petitions.
No, they say that.
What exactly is the pleadings?
Ah.
The petitioner especially may feel reticent because of the pleadings is there on record. So that way,
Again,
I mean, the more maneuverability or leeway in the more play in the joints.
and dispose of Hangala, I'll be benefited. The second time I may.
Correct.
So I don't want that. So let it be there.
But I have clarified that.
Sir, sir.
Yes. And if it is done, then please mention. Liberty to mention is there.
Again.
So that it can be disposed of in those lines.
My lord.
Item 20, in this case, I have appeared today
For
for opposite party.
anyone from Mr. Burma chamber? Sir, you are filing Oklatama now in court in the registry. Sir, your name, sir,
Sanjeev Kumar Rathod.
and associates.
Yeah.
Okay. Filed appear today. Aji appear kale.
Today itself.
Oh. We should have requested NFF trade. We should not have, with a fractured limb or injured limb, we should not have stayed back. Would have informed anyone. So item 11 ta ki nahi kile? Kitne saal back kile? Upon that. बात कॉल करंतु देखियो कोन चलांतु ती
Achor item 6.
मेंशन करथली आपण बोधे मेंशन करथिले
सर पास ओवर पे कोथिल सर आउ दी टू पास ओवर सर
नहीं नहीं सेमती हेले आपण अदर साइड यू आर मेकिंग हिम अ लाफिंग स्टॉक Mr. Sanjeev sir always said that, sir, why we will wait for after recess, and because they have their work also.
Pardon my lord.
Are you how I can pardon you for them? It is for them to pardon or not.
Sir,
ସେମାନେ ତାଙ୍କ କାମ କରିବେନି କି? Are they are also busy,
sir,
and that's a valid point.
sir,
They have to. They have a lot of work. Back office work is more for him
sir.
because he has to issue notice. Otherwise, the requisite file over here was so.
Sir, praying for
ଆଉ ଗୋଟେ short adjournment ନେଇ ଯାଆନ୍ତୁ ଠିକ ଅଛି ଦେଖିବା ଟିକେ ଟିକେ ଅପେକ୍ଷା କର
sir.
ତାଙ୍କୁ ଆଉ ସେ କୁଆଡେ କଣ ଟ୍ରାଏଲ ରେ ଯାଇଥିବେ ତାଙ୍କୁ ବ୍ୟସ୍ତ କାହିଁ କରୁଛନ୍ତି ଆପଣ ତ ନିଜେ କରୁନାହାନ୍ତି
May
ଏଗାରଟା ଗୋଟେ ଆଡ୍ କରିବେ ଆପଣ ବସନ୍ତୁ 11ରେ ବୋଧେ ବ୍ୟାଚ୍ ଅଫ୍ ମ୍ୟାଟର୍ସ ହେଇଯାଇଛି ନା ଅଲଗା ଅଲଗା ଅଛି ୟେସ୍ ବ୍ୟାଚ୍ ଅଫ୍ ମ୍ୟାଟର୍ସ ଆଉ ଗୋଟେ ମ୍ୟାଟର ଆଡ୍ ହବ 18496 এটা সে লিমিটটা ফাইলে লগাইবে আপনার পাখে কিটা কপি আছে আছে ঠিক আছে being mentioned by the learned counsel for the petitioner as well as the opposite party Mr. Lenka, kindly take your seat এটা item 11 back which আপনারা বসুন তো the matter is taken up after being listed as a listed in special notice at 2 p.m. Copy of the notice is kept on record. Roughly. File that? File debe apun. Same order. ऊपर जो लाइन लिखी है कि mistake being mentioned. जो line add करो तो being mentioned by so and so बसंत लेकिन. The counsel for the petitioner as well as the opposite party. The matter is specialist. It is stated that similar matters are listed today at serial number 11 of the list, cause list, and this matter is left out. ତାପରେ ଅର୍ଡରଟା ହେବ। କଲ୍ କର ଆଇଟମ୍ 6 ପାସ୍ ହେବ। ଆରେ କେମିତି ସେମିତି କରାଯାଏ? That's not the way to conduct a court proceeding.
Matter tomorrow.
We are liberal in doing this, but it should not be the norm actually.
Sorry, sir.
ଆରେ why you are saying sorry? ଆପଣ ବୁଝିବା ଦରକାର। ଇମ୍ପୋର୍ଟାଣ୍ଟ ହେଲା ଆପଣ ପଛରେ ସରି ନୁହନ୍ତୁ କିନ୍ତୁ ବୁଝନ୍ତୁ ଜିନିଷଟା। ଆପଣଙ୍କ ନାଁଟା କଣ କହିଲେ? ପ୍ଲିଜ ଟେଲ୍ ଅଗେନ୍।
Vishal Samantray.
Mr. Vishal Samantray.
Sir.
B for Bombay.
Yes, sir.
Bhubaneswar.
Yes.
Mr. B. Samantray on behalf of PC Jena for the petitioner. Mr. Dayanandhi Lenka AG for the
State, only party.
party, the state. कौन है? Economic offence PS. The allotted counsel for the petitioner seeks for adjournment in absence of his leader. Accordingly, the matter shall be day after पूछेंगे।
In the after tomorrow.
After क्या बार होगा? शुक्रवार ही परियो। 30 बजे। मिस्टर 30 एक 24। Yes. Yes, next call करो तो पास होगा।
Yes, my lord.
Yes, please.
My please, Your Lordship.
Yes.
Your Lordship,
Requisites file नीचे।
requisite आज ही file है Lordship.
Okay, okay. आपका ना
Rajit Mahapatra, Lordship.
पावर नहीं।
No, sir. No, Lordship.
Rajit Mahapatra.
Ranjit Mahapatra.
Ranjit.
On behalf of my senior
Mahapatra,
Lordship.
on behalf of J. Pal for the appellate.
State, I am for state.
Yes. Mr. Prem Kumar Mahanti, Additional Standing Counsel for OP1. 2 and 3 blank. None appears लिखी। केबे notice issue हुई थी?
Lordship.
Pursuant to it is submitted by the learned counsel for the petitioner that pursuant to the order dated 12/1/2026, the requisites for issuance of notice, issuance of admission notice, to R3 has been filed in the registry today. Has been filed in the registry today. The registry shall verify and proceed for issuing notice to the R3 as directed by order dated 12/1/2026. List after SR liberty to mention. Yes.
Item 13.
Orders for fresh admission. Orders. Then simply adjourn got a date कर दिया तो। देखो कॉल करो तो।
15.
I met with the lordships. As this is an application for restoration of the WBC number 31386, and I filed because it was filed late, I filed a delay condemnation application, that is IN number 208 of 2023, wherein I couldn't, in fact, initially explain the thing where for which I was not able to contact my counsel after engaging my counsel. So for that, I filed an additional affidavit on 10/11/2025, wherein I have explained.
आपण ऑर्डर से आर्ग्यू करो तो आपण मिलिट्री का आर्ग्यू कौन पे ऑर्डर से आछी आगो कहबे
सर ऑर्डर से डिले करने में
ना हम पढु ना तो सेला प्रॉब्लम आपण एते बॉस रा कोन हबो क्या हबोनी कौन पे आछी आपण देखिलेनी सेटा कोर्ट रो काम से करिवे आ ठीक कथ नो इशू
minutes I have explained the
ଟିକେ ଏନେ ହୁଅନ୍ତୁ ଆଜ୍ଞା ଆପଣ କହିଲା ପରେ ବି ଆପଣ ଅଟକୁ ନାହାନ୍ତି ଏ ଆପଣନାହାନ୍ତି ବୋଲି ନୋଟିଂ ଆସିଛି
sweep 3 ta sufficient है जो number 3 1 2 by my only friend is appearing
एक सार कॉज लिस्ट दियंतु ना पेपरलेस यूज करेंगे ना कॉज लिस्ट देखिए office note photo by the registry indicates that notice issued notice on OP number 3 has been returned after valid service, but no counsel has yet appeared.
Yes. For OP number 3.
Number 3.
I have filed it. Thereafter.
Since the matter is already disposed of, notices were issued. The Director Higher Education shall ensure presence of the OP number 3 in person. If they are not engaging any counsel, after the notice is sufficient, having been issued by this court, the copy of this order obtained from the official website shall be forwarded by the London Additional Standing Council to the Director of Education to do the needful. से आपण अंडर रे अछंती तो पचार देटी कोन माने गुआ ना आपण ऑफिस रे गुआ जीवो ना कोन
I will inform.
बागर सीजन में गुआ चले तो जनो एबे तो गुआ उठी गलानी एबे गुआ दो नांती इनविटेशन कार्ड हे गला आपण ओड इनविटेशन कार्ड आपण तो ना आपण को ना जा आपण लिखिले संग संग आसीबे बुझले जी सर non-repudiation is a serious matter. A disposal of matter, say the right accused in their favor. अपन मेरिट रैंक जहाँ भी कहबे मु अलाउ कर देबी तापर से फाइल करिवे जे से कि जान कि बुझी पनंती कि जान ना
So lords fix a bit.
So Prem Kumar will tell now. केबे कोन सर केबे कोन कहि पाए दक्ष दिन 2 सप्ताह परे
After 2 weeks.
डेट करो 16 वीक तक रखियो 9 रखियो ना 23 रखियो लिस्ट 9 2 नहीं इतने रखो तो दैट सफिशिएंट नोटिस सफिशिएंसी पे लिस्ट इन द वीक कमेंसिंग 23 2 20 26
Oblige.
Says D Sahoo for the
May I please the let's say.
Mr. Misra? Yes, Mr. K. Misra for the opposite party. Has been listed for
Yes, sir.
objection time.
Latif, I already have received the objection. Kindly had the IA, let's say, for condemnation.
Serious objection.
Yes, my lord. There is a delay of 660 days, my lord.
Cost?
Yeah, cost is not material, my lord. The is that, my lord. The area dues is, my lord, till that, my lord, 5,36,000, my lord. After filing,
no case for condonation of delay.
Let's say, there was communication gap between the conducting counsel and the petitioner, present petitioner, let's say. For which
communication gap
for which
because now you are aware of the decree you are challenging. Area is in 5 lakhs. So how I will justify my order? Just imagine what he will argue in Supreme Court.
let's say if I received the NBW letter, let's say on
So execution has to be there.
yes, let's say 24th of March.
So you obtain instruction, take a short adjournment. How to what extent he will now satisfy the decree, to what percentage? At least 50%. At least 50%. But actually 50% is not to be reasonable with the other side. But still, since you have approached the court, making an effort, obtain instruction.
Let's say I will
2.5 दियंतु तापर स्टे नियंतु
1 lakh, let's say.
ना
I will
तो
deposit.
सुप्रीम कोर्ट गले मोर से अधिकार सी तो बर्तर स्टे करी रखछन डिक्री टा usually that this is happening in case of maintenance the parties themselves stay. I don't want a commitment so that it will create more complication, but you obtain instruction. IA lekhantu. Sorry. IA 207 of 2025. Pursuant to the notices issued by the order dated 18/8/2025 by the coordinate bench, the opposite party has appeared through London Council and filed objection to the IA, which has been filed for condonation of reported delay of 574 days.
Let's see, for the cost is for the son, let's say for minor son. Divorce already has been granted by paying permanent alimony, let's say. This amount which has been arreared, let's say, that is for the son.
So best perhaps better. I mean, in the situation like that, you show the court that you have already deposited for the son. If the permanent alimony or the maintenance amount for the son is not granted,
Let's see.
how that will help you in getting over this decree?
Let's see, I will take.
To take instruction.
Yes.
It is submitted by the learned counsel for the petitioner that the amount of award is 12 of the minor son. Stop. After grant of decree of divorce. Divorce upon challenge koruna.
No, ma'am.
Between the petitioner husband as well as the opposite party wife in the marriage. Permanent alimony of an amount of rupees
7 lakhs, let's see.
7 lakhs as directed has been deposited.
Already paid, let's say, by the demand draft numbers.
Deposit had been paid and received by the opposite party.
No.
Stop. It is submitted by the learned counsel for the opposite party that the area of maintenance payable for the minor son who is being maintained by his mother is around 5.5 lakhs.
5.7.
5.7 lakhs. Is
70 lakhs.
5.7 lakhs.
70 lakhs, ma'am. It's around 5.7.
5.7 lakhs. Para. For seeking condonation of delay for the matter to be heard on merits, the learned counsel for the petitioner has adjournment to obtain instruction as to what amount the petitioner shall deposit to secure the money. Secure the amount due, which is in the nature of a money decree. DECRW. Kebe, Mrs. Sahoo Kebe.
Let's see, 2 weeks time.
List. The week commencing 9/2/2024.
Yes, sir. Let's see, may I pray one thing? When I received the NBW letter, your lordship, there the maintenance amount was written 1,80,000. That is on dated 18 March 2025, lordship.
Suppose here I am asking for 5.7, 50% is 2.85. Correct. So there the code which has issued NBW is for 1.5 or 1.8.
1.8, your lordship.
So which one you will prefer? High Court or that code, the executing code? It is your choice.
High Court.
I'll be happy if you come here and deposit 2.85.
Yes, sir, lordship. I will take it.
There is no mandate by this court that you execute the warrant. So it is your choice. Apart from becoming Supreme Court and High Court, you can satisfy the decree. You satisfy 1.85. At least, I mean, that is the way you can ensure this compliance, because otherwise they will not listen to you. Unless the petitioner's counsel has a decree and a warrant like this, they will never listen to you.
Let's see, I will take it.
It is very fortunate. It is much becomes easier for you as a counsel to manage the person.
Yes, sir.
You have to tell him that the High Court wants 2.85. And the decretal, the executing court wants 1.85. So it is his choice. Yes.
As on 4/7/2003 decree, 2,56,000 was the outstanding total.
Again, देले तो किछि हबो
नहीं मुझे 50% दे देले
से दौ नांती एमतरे चालुची केस भी सरिवार नाही किछि नाही इनफैक्ट मैट्रिमोनियल केसेस कोन चलछि आपण किछि बुझी परिबेन माने where it starts, what is the purpose, what is the course of movement, and where it will end.
Yes.
Nothing is comprehensible. Yes.
Bless.
Meeting.
তিনটা সিম্পলি ଗୋଟେ ଡେ କରିଥାନ୍ତୁ adjourn କରିଦିଅନ୍ତୁ ହେଲା ଆଉ ସେକେଣ୍ଡ ହାଫରେ ପାସ୍ ଓଭର କରିକି ରଖନ୍ତୁ ପେଣ୍ଡିଂ ରଖନ୍ତୁ କଲ୍ କରନ୍ତୁ ଆପଣ
19,
yes please
19.
you are appearing
Yes, Your Lordship.
ଆପଣଙ୍କ ନାଁ
On behalf of Mr. R.K. Sahu, madam.
Item number 18.
yes let me know his name अरे ଆଜି ଗୋଟେ ସମସ୍ତେ କଣ on behalf of ନା ହେଇଗଲାଣି ବବଲୁ କହିଲେ ଯେ my name is on behalf of ଆପଣଙ୍କୁ ବି on behalf of
No, madam, I have no power.
no power ବି ନା ନୁହଁ what is your name sir
Hon'Ble Kumar Barik.
Hon'Ble Kumar Barik
Yes.
oh both are Bariks that is on behalf of coach ठीक है that is the only similarity Mr. Hon'Ble Kumar Barik on behalf of R.K. Sahu for the petitioner opposite
Madam,
party
item number 19, madam.
yes
Yes, madam.
ଆପଣ
Adjournment.
petitioner ନୁହନ୍ତି କି
Yes, madam.
ଆରେ ମ୍ୟାଡାମ କହୁଛନ୍ତି ସେ appear କରିବେ ତାଙ୍କ କଥା ଶୁଣିବନି
Madam, for the item 18.
oh then I am confused I am thoroughly confused I have mixed up 18 and 19 ଦିଦି ଯାକ submission ମ୍ୟାଡାମ ସେ ତ ନାହାନ୍ତି then why were you want
Sir, आज notice पठेबो time दरकार थिला.
ଆପଣ ପିଟିସନର ପାଇଁ 18 ରେ
Yes, Your Lordship.
ଆଚ୍ଛା ସରି ଆପଣଙ୍କ ନାଁ
Pragya Alina Das.
Miss Pragya Alina Das on behalf of B.K. Ragada for the petitioner you took lot of time actually to respond when I said he also sat then after that you came up so I could not realize that it is the same matter
Will
on behalf of
submit
Mr.
all
B.K.
the
Ragada for the B.K. Ragada for the petitioner Para. Office note put up by the registry indicates that notice in the limitation matter could not be issued to the sole respondent due to non-filing of requisites.
We'll file it today, Your Lordship.
It is submitted by the learned counsel for the petitioner that the requisites shall be filed by tomorrow. Para. Upon filing of the requisites, registry shall verify and proceed to issue notice to sole respondent. Yes. List after SR, liberty to mention.
19,
19, my lord.
Actually, Mr. Akona Pragya କେମିତି ହବ ସେ ବି confused ହେଇଗଲା Mr. Hon'Ble Kumar Barik on behalf of R.K. Sahu for the petitioner.
Adjournment may be given.
The same what Miss Das said your case is also same
Yes.
requisites not filed adjournment କେମିତି ହବ orders ପାଇଁ ଆସିଛି
So, my amicable settlement is going on, so one week time.
notice ସାଙ୍ଗରେ amicable settlement କେମିତି ହବ
So, oh, sir.
court cannot put its foot in the mouth disease once it will issue no notice because the bench is changed now I will direct for amicable settlement
No, man.
you at least maybe they will appear through your some counsel you make them present I cannot modify the coordinate notice order once it has notice have been issued
Yes. 1 week
then
time.
simply adjourn 1 week never
1 week time may be given.
ठीक है the learned counsel for the petitioner 6 for the submits that notice pursuant to the notices issued by the coordinate bench by order dated 1/12/2025 requisites have not been filed further 1 week time may be granted accordingly requisites for issuance of notice be filed within 7 working days peremptory order otherwise it will be listed for dismissal because here you have to pay maintenance whenever there is a payment of maintenance now after 1/12 we are now entering February please appreciate that then it will be 2 months 2 months is more reasonable court should allow this kind of a thing but since you are saying I am allowing it
Grateful.
list for orders in the week commencing? No, not 9/2/26. Yes, next call for it.
Item 20.
Nahanti. Petition. Are say petitioner ko pain. Apono Sanjeev. Petitioner none. Opposite party blank. Office note put up by the registry indicates that notice on admission and stay issued to OP number 1 and 2 by speed post with heading has not been returned. Stop. Para, however, comma. So Sanjeev Kumar Ratha submits that he has instructions to appear on behalf of the opposite party. Parties for the plural. Parties. He has filed his he and other associates have filed Wakalatnama in the registry today. Registration. The official locate the Wakalatnama, tag to the file, scan copy, we update it. Stop. Upon tagging up of the Wakalatnama, name of Mr. Sanjeev Kumar Ratha and associates shall be indicated in the cause list as well as case brief appearing for the opposite party.
Pardon my smell. Item 20, my lord.
20, Mr. Pasad.
My lord.
Mr. B. Pasad for the petitioner. So Ratha is appearing today. He has some difficulty as a injured hand. So yes. Se କହିଥିଲେ କେବେ କେବେ Mr. Prasad ଆସିବ କୁହନ୍ତୁ
ଆଜି ଲକ୍ଷ୍ମୀ
ଆପଣ
Week commencing 2/3.
list in the week commencing 2/3/26.
Twenty-one.
The case is ready.
Yes, please.
Petition counter is under, everything is there. But I have some difficulty today because the matter is fixed at 3 p.m. As permit me, it can be done tomorrow or day after.
Tomorrow day after not possible. Maybe some little bit longer adjournment. 16th week I am not. 16th February that week difficult for me. I have some particular. Kebe as per you? Week commencing 23rd February. Mr. S.S. Rao, senior advocate, along with Mr. B.K. Mohanty for the petitioner. Mr. P.K. Sahoo, additional standing counsel for opposite party. Other than state in the opposite party, Mr. Rao, for the opposite parties. The matter is listed for admission hearing. List in the week commencing list in the week commencing 23/2/26.
Item 22.
May I please, Your Lordship?
Yes.
Lord, in this case, I'm for the appellant. The appellant has challenged the order dated 30th 9th 2015.
Yes.
Passed by the learned senior civil judge Noyagad. As they enhanced the awarded amount passed in LMS. My lord.
Is it covered by any decision of this court?
My lord, some in the same area, some judgments has been already been passed.
But is the opposite party heard? All the parties are heard by the referral court?
Yes.
All were parties, all were heard.
Yes.
So that point is not available.
No.
Because there are 2-3 judgments of this court, following Supreme Court, that the affected party need to be heard.
Yes. Here in this case, my lord, the
respondent has not been able to prove his case. So the other connected plots regarding the higher rate.
Constructed.
Only on guesswork, the awarded amount has been enhanced. Guesstimation, on the point of guesstimation, this has been enhanced. I am relying on one judgment that in few cases, in some limited cases, the guesstimation is my lord calculated, otherwise not. And my lord, I am here.
Mr. Naik, I mean, you are seriously contending that there is no discussion about any evidence.
No,
Nothing.
that is in my favor.
It is guess and
Yes.
estimate.
Yes.
Just as
All other points in my favor. Only on the point of guesstimation, the award has been enhanced. And it was
Mr. Samantra, you will reply today or you will prepare answer to that because it's a legal proposition. The referral court answers every point in favor of the requisitioning authority.
Yes.
Here is the project proponent.
Yes.
All other points answered in favor. Only point answered in your favor is that similar plots have been granted but no discussion on evidence.
Yes.
Then what would be the conclusion? What should be the conclusion of the referral court? Any further factual dispute? I don't think there is any scope for this court in a LA to examine factual aspects. Unless there is a reasonable conclusion cannot be drawn based on the facts available.
Yes.
Suppose village is changed. X village acquisition, the court went on Y village. Or Mr. Naik's case is same. The acquisition is Y village, but Mr. Naik is arguing X village. So that kind of a fact I have to take note of, but otherwise there is very limited scope for me to examine the facts. What do you say or you propose?
Let it come some time.
Please share your decision to with Mr. Samantra.
Decisions is there. Some
I'll
decisions
record
in
this
my
information.
favor.
The time we have spent today in discussing, I'll record this.
Let it come next week, my lord. In the meantime, my lord, I will produce the.
Next week may not be possible. We'll try to, because these are up to notice matters, we'll seriously try to handle. But so I'm not, deciding it today, not observing my conclusion also. But if I do not make the, record the submission, then it will be difficult for you, for him also. And definitely court, it is difficult for the court to remember everything.
I'm expected that, my lord, why I'm saying so, my lord, last week, my lord, in the meantime, my lord, we stated a judgment before this honorable court, my lord. In the meantime, my lord.
But appellant's argument, how can I foreclose? You have to respond to the appellant's contention.
A similar case, my lord, similar case, other case.
Similar case, it is not decided on law, even
one case, same case, my lord, one case, my lord, that is 16 of 2016, same case. This is the system, same petitioner, same opposite party, my lord. That is the award.
Sir, if you want to help the court, you have to show this court that this question has been answered by a coordinate bench or a division bench. That yes, it can be done.
Let me examine, my lord.
So you examine. So it is up to you. I'm granting you time, no difficult.
Next week, my lord, Monday, my lord.
Then next week, I will occupy.
My lord, what I am saying so, my
piecemeal hearing becomes very difficult, and for if this court has assignment of land acquisition appeal, we should make an effort for hearing of the matter. So whatever efforts we have made today, what is the difficulty if I record that his submission and adjourning?
28 to 30 marriage year. That's why Monday, my lord. Last chance, my lord, Monday.
Monday should I am adjourning the matter. Why you want in Monday? I don't understand. I am not following you actually. I am granting you adjournment. Upon Monday, can you?
Yes, my lord. I'm sorry, I am not understood.
My lord, should I submit the depositions today?
No. That day you made your point. I will record that.
No.
But Mr. Samantra has to answer that. So that is how I said that he should answer. Mr. This is item. Naik, Senior Panel Counsel for the appellant. Appellant Union of India. Mr. P.K. Sahoo, 22 P.K. Sahoo. Mr. 22, Mr. P.K. Sahoo, Additional Standing Counsel for the OP number 1 and 2. Mr. Samantra, J. Samantra, for OP number 3.
Respondent now.
For R3. Sobuda appellant respondent are three. You take your seat. I'll take some time. We submitted by the Learned Counsel, Learned Senior Panel Counsel appearing for the appellants that the referral court in a reference under section 18 of the Land Acquisition Act, 1894, in the referral court, the referral court, Court of Senior Civil Judge, Noyagarh, in a reference under section 8 Land Acquisition Act, 1894, has enhanced the amount of compensation which is under challenge before this court. It is submitted that the referral court was pleased to answer all the points in favor of the appellant's public project proponent. However, resorting to guesstimate, GU guess plus estimate, the amount of compensation has been enhanced to rupees 1,50,000 per acre. Instead of earlier awarded amount of rupees
90.
rupees 90,000 awarded by the NA collector in the proceeding. In the NA proceeding. L capital dot A capital. He relies on the decision rendered by the apex court in or High Court.
Supreme Court.
Supreme Court
in my lord, Bhuleram versus Union of India. And civil appeal number 6251 of 2010.
तो पहले citation था नहीं?
नहीं
Copy. Citation ना था? SCC है?
SCC.
In Bhule, BHULE space RAM versus Union of India. EIR 2014 SC 1957. 2014 into bracket 3 SCC. नहीं भूल है into bracket 2014 bracket closed 11 SCC 307. Legal. Whatever it is. To support his contention. The matter is listed for admission hearing. The Learned Counsel for the R3 has adjournment. List in the week commencing 2-3-2026. Yes.
43.
23, my lord. I'm
Yes.
answering to the petitioner and there are no instruction about the status of the petitioner, my lord. I have filed a memo to that effect, my lord, which is in flag C, my lord.
So disposed of with liberty.
Yes, my lord.
So Bera, My lord. Can you have anything to say? I mean, regarding this?
No, no.
Mr. S. Mohanty for the petitioner, Mr. A.K. Behra for the opposite party. Learned counsel for the petitioner submits that despite her efforts to obtain instruction, the petitioner remains incommunicado. Clerk, कितने कहले सेटा?
C, my lord.
C. She refers to the memo dated 21/2026, which indicates thus. He refers to the memo filed by her, filed by her 21/2026, which indicates thus. Accordingly, stop. The writ petition is disposed of, granting liberty to revive the same within 90 days.
Yes, ma'am. Obliged.
If any further cause of action survives, and upon receipt of instructions from the petitioner.
Obliged, sir.
Yes.
Item 24.
Mr. Das.
Right.
This is a case for grant of family pension to the widow's daughter. And I have filed a note of submission, also some judgment of this Hon'Ble Court holding the field.
Who is responding to you?
My lord, state.
So now you are there.
My lord.
So today,
I request my friend that citations. Only reference.
अच्छा अच्छा सर सब कितने उड़े इन्होंने
available.
this item plus Urbosi.
That
कितने उड़े
Sahoo.
I would recent judgment.
Judgment which has been referred.
Rajasthan High Court is there. This High Court
Yes,
prison bench by me.
Only one argument they can advance. Because now my lord knows in 2025 they got an amendment to the Rule 56 saying that this widow's daughter, if widow at the time of living of his father with a pensioner. But that my case is it is a case of 2022. This amendment is prospective. It cannot have an application. This much of my argument. He can aid that.
You examined and answered.
He can aid that only. ଆଉ କିଛି ଅଧିକା କରିବାର ନାହିଁ ଆଉ ନହେଲେ ପଏଣ୍ଟଟା ସମାନ ମୋର କେସଟା କ୍ଲେମଟା ରିଜେକ୍ଟ ହେଇଛି ଫାଦର ମରିଗଲା ତାପରେ ମଦର ପେନସନ ପାଇଲା ବେଳେ ଇଏ ୱିଡୋ ହେଲା ପରେ ଡିପେଣ୍ଡିଂ ଅପନ୍ ଦି ପ୍ୟାରେଣ୍ଟ ତା ହଜବେଣ୍ଡ କିଛି କରୁନଥିଲେ ଇଏ ଡିପେଣ୍ଡିଂ ଅପନ୍ ଦି ମଦର ନାଉ ମଦର ଡାଏଡ ଦେୟାର ଆଫ୍ଟର ଆଇ ଏମ୍ କ୍ଲେମ 56 ଇ ସେଜ୍ only family pension mother mola pore je claim କରିପାରିବ widow daughter. That is Rule 56.
You have filed a counter saying that is not applicable.
সেটা পুরোনো counter.
এটা 56(5)(b) my friend is relying. That is for other purpose.
Who purpose?
Yes.
পড়ুন
I have gone through. So far as the counter relies Miller, the every notification of 23/7/2011, this statement para 4 page 4 is correct. Page 5 relying on Rule 72, which is not applicable. Rule 72 is applicable to those persons, pensioner, those government employees who died while in service. But
which paragraph of the counter you are referring?
Para 5, page 5 of the counter, state counter.
Page 5, para?
Here also see page 4 first. Page 4, top Miller.
No, page 4, page 3 actually para 6 starts. So you did from para 6 completely, not few lines only.
Yes, Miller. I am only referring that FD notification the counter says where the deceased pensioner is survived by unmarried so-and-so. What is the became widow and so-and-so that then she is not entitled. My responsible submission will be the next page you also see there is a error, Miller. Is relying on Rule 72C, but I find that is not applicable. That is applicable when the government employee died.
Mr. Sahoo, the effort is since we are is for hearing, after notice hearing. So you have to be specific in your response.
Yes, my lord.
So that will be specific so that he will
Yes.
be replying to you,
Yes.
your
I
contention.
an additional affidavit is necessary because I really rule 80, 82 capital B surplus 3. That is the exact provision.
And where you have stated regarding prospectivity of the applicability of the amendment.
So far as amendment, the counter does not rely on.
That is a recent amendment. Then he might not.
No, he
You
said
go
that.
through.
Yes,
He
he
clarified
said
that you could not have stated anything in your counter because it is a recent thing.
Yes.
But since it is a statute,
Yes.
he has to answer that.
Yes, my lord.
Statute always to be answered even if not pleaded. So his answer, his contention is that it will be prospective.
Prospect. Yes.
So that also you have to get over that
Yes, my lord.
submission.
Yes. List of citations by senior may supply. Only list.
How
Yes.
did it? Who had
I'll collect
they did?
those. Because I have got, if the proposition what I was finding, Lord, if this is to be allowed, my Lord, then that will open whenever a person, the husband of married daughter died, he will again claim, my Lord,
No.
pension. Here, on the date of death, my Lord, she was not widow.
Sir, these things have to happen. Whenever, suppose the daughter is widow.
Yes.
Widowed. The mother survives, she cannot get. That is not the contention also.
But here the contention is on
After death of the father, after death of the mother,
yes,
then she will come into picture. That is the contention, long and short of the case.
Yes, that is the petitioner's case. My response submission will.
So whenever it cannot be there.
The claim is made long after because the husband of the daughter
The mother যদি বঞ্চিত how she will claim.
That is there.
So your answer that mother is getting.
Statute provides on the date of the survived by whom? Who are eligible?
So what is different? I am unable to understand. Suppose mother is alive, how she will claim?
But there is a
because family pension is devolves upon the widow, not the daughter.
Yes, my lord.
In normal circumstances. Now, if a widowed daughter is there, in absence of after demise of the widowed mother, then what would be the case?
But I was thinking, Lord, if a married daughter, suppose let us think of a case.
Yeah, the petitioner is not thinking, so why would we discuss?
Married daughter.
Petitioner is
when
not
the
claiming.
father died. Yes, when the father
Petitioner
died.
is not claiming during lifetime of the mother. Please appreciate that.
That is his case.
So if I start, no.
The statutory provisions, what I found, my lord, on the day.
Maybe it is there. I don't know, but that is not the submission today. That the submission is that after death of the mother, she is claiming.
Yes, his case is he was depending on the mother, and he after the mother. But my response submission is when the eligibility has to be seen, whether on the date of death.
No, why we will formulate a question which is not which has not fallen for answer to be answered.
I will place my lord. I will
Suppose you say that during the lifetime of mother, then the court will take up that the petitioner is not saying that. So then what is the point in discussing that?
There is a long gap, my lord. 2002, probably the
mother was alive. Mother died in 19.
I understand.
He is not answering.
That he is not getting
I
that.
have told him thrice.
Yes, my lord, giving the hints also. He is not getting that.
I will file an additional.
What is this? The judgment,
Yes, sir. Gone through the judgment you have referred to that is related to
all these cases, identical cases. Our data भी आज भी है recently I was thinking.
So far as the
Das for the petitioner. Das for the petitioner, Mr. P.K. Sahoo, Additional Standing Counsel for the opposite party. The matter is taken up for after notice hearing. It is submitted by the learned counsel for the petitioner that the entitlement of widowed daughter after death of her mother, who was receiving family pension for the services of her father, that is deceased husband of the mother, is no more res integra. जो डेट चार्ट रे आपन साइटेशन उडा कर दैछन
यस सब दिन और केतोडे भी दे देबे और नुआ भी एबे रिसेंट लास्ट वीक रे भी जजमेंट हिची नेक्स्ट टाइम मु दे देबी ताको भी दे देबी ताको कोर्ट
से जोडा का WPC 2879
आगे
6-7 रे आपन दैछन
आगे
सेटा तो
सेउडा और के एबे लास्ट मु आज
he refers to the The list of dates furnished wherein the list of cases have been indicated in the under the heading court submission. But referring to the recent amendment, so that's date amendment.
Date 25
Amendment in the year 2025, the year 2025 to the OCS pension rules, wherein amendment has been brought
29/5/20.
Yes, he got 29/5/25. Yes.
29/5/2025, wherein amendment has been brought to the 56 to rule, okay?
92 এটা হচ্ছে 19 মে 25 রে ହେଇଛି
19 May 25. Notified on 25 May 25.
ଆଜ୍ଞା ଏଇଟା ନୋଟିଫିକେସନ ଦେଖ ସେ ତାପରେ ଗୋଟେ ରେଡି ରେକର୍ଡ ନଦେବେ ବୁଝିଏ
Police Part 25. The rule was OCS pension rules from 1992. Wherein a proviso has been added to sub-rule 2 of Rule 5. Details ଦିଅନ୍ତୁ ବହୁତ ଗୁଡେ amendment ଅଛି
ଗୁଡାଏ
ୟୁଜ କରିହବ ନା
ଖାଲି amendment କରିଦେବେ ସେ ଦେବେ
ସେଟା B ରେ ମଧ୍ୟ ସେଟା ଅଛି ଏଥିରେ ନେକ୍ସଟ ଥାର୍ଡ ପେଜ ରେ ଅଛି
ଆଜ୍ଞା
referring to the pension rules 1992 is submitted by the council the task that said amendment applicable to the case of the petitioner or otherwise shall be prospective in its operation. The learned additional study council in response refers to paragraph 6 of the counter affidavit filed by the OP number 3 and submits that he shall obtain further instructions in the matter. The matter shall be listed for admission in the week commencing North in 2026.
February pension
February 23 କହିପାରିବେ
23/2
23/2
Hon'Ble
23/2 2026
46
And for the wife opposite parties.
Yes,
the needs of animal.
Mr. B.B. Mahapatra for the petitioner, Mr. S.K. Jetli for the opposite party. The matter is listed for admission hearing. The learned counsel for the respondent seeks some further time to advance arguments.
And file
The matter shall be listed for admission in the week commencing 16/3/2026. Mr. Mahapatra?
Yes, Lord.
Yes.
27
Order is there, Mr. Mahapatra?
No, Mr.
Yes.
Prior to that, this matter was heard before the Honorable Judge Sanjay Kumar Mishra bench. In the meantime, the counter in the rejoinder has already been. The matter is regarding.
You are Mr. Sodangi. Mr. Kedar Chandra Sodangi for the petitioner. Mr. P.K. Sahoo. Additional standing counsel for all the opposite parties. Yes.
Ultimately, on dated
ration card ମିଳୁନି ଏପର୍ଯ୍ୟନ୍ତ ମିଳିନି ନା ମିଳିଗଲା
ରାସନ କାର୍ଡ ଆମର ଅଛି କିନ୍ତୁ ଆମକୁ ସାମଗ୍ରୀ ଦଉନାହାନ୍ତି ଡିଲର
ଆପଣଙ୍କ ରେଜିଷ୍ଟ୍ରେସନ ହେଇନି
ହଁ ଅଛି ଆଜ୍ଞା ସବୁ ଅଛି କିନ୍ତୁ ଆମକୁ ଦଉନାହାନ୍ତି
ଆପଣ ଏଲିମିନେଟ୍ ହେଇଛନ୍ତି
हाँ हमको दौनांती तो से डीलर हमको दौनांती
ଏମିତି କେମିତି
ଦଉନାହାନ୍ତି ଆମେ
ସୂର୍ଯ୍ୟ ଅଛନ୍ତି ଉଦୟ ହଉନାହାନ୍ତି ତାମାନେ ଗୋଟେ ମେଘ ଉଠେଇଛି ନା ଆଉ ଆପଣ ମେଘଟା କୋଉଠୁ କଣ ଅଛି କୁହନ୍ତୁ ମେଘ ବିଷୟରେ କିଛି କୁହନ୍ତୁ ଆପଣ ତ MS ହାସନ ଆପଣ ତ ଷଡଙ୍ଗୀ ନୁହଁ ଆପଣ ୟୁଆର ହାସନ ନା ତ ସବୁବେଳେ କଣ ମୋର ମନେ ରହିବ ମାନେ ଆପଣ କହିଦେଲେ ମୁଁ ଡାକିଦେଲି ଷଡଙ୍ଗୀ MS ହାସନ ଫର ଦ ପିଟିସନର
Lordship, the petitioner is an handicapped person.
No,
having
what is the
ration
issue,
card.
sir? Why he is not getting, sir? His name has not been. ମଝିରେ ଗୋଟେ ଇଣ୍ଟେନ୍ସିଭ ରିଭିଜନ ହେଲା ଆପଣଙ୍କର ବେନିଫିସିଆରୀ ମାନଙ୍କର ସେଇଥିରେ କଟିଗଲେ ନା କଣ ହେଲା
ହଁ ସେ ତ ଦଉନାହାନ୍ତି ଆଜ୍ଞା ଆମର ଆଧାର ଯୋଉରା Lordship, kindly page glance the page number annex 2 page number 14. Lordship, ରାସନ କାର୍ଡ 7 ଜଣଙ୍କ ନାଁ ଅଛି ଫ୍ୟାମିଲି ମେମ୍ବର୍ସଙ୍କର ଆଉଟ୍ ଅଫ୍ 7 ମେମ୍ବର୍ସ ଆମେ କହିଲେ ଆମକୁ ଇଏ ଦେବା ପାଇଁ ଆଧାର କାର୍ଡଟା ଦେବା ପାଇଁ ଆମେ 4 ଜଣଙ୍କର ଆଧାର କାର୍ଡ ଦେଇଥିଲୁ ଆଉ 3 ଜଣଙ୍କର ଦେଇପାରିଲୁନୁ ସେଇ ପାଇଁ ଆମକୁ ଦେଲେନି ଆଉ
ପ୍ରୋଭିଜନ ଦେଖାନ୍ତୁ ଯେ ବିନା ଆଧାର କାର୍ଡରେ ହେଇପାରିବ because modified PDS has become stricter as far as identity is concerned.
Due to delay of non-submission of Aadhaar card, the dealer did not refuse to give the ration commodity.
If he gives, his license will be
after that the petitioner deported
will be cancelled. If he gives ration to persons who are not otherwise entitled, or he doesn't have the record. Suppose now after you have given your Aadhaar card, did you approach the authority? As you are saying that you have given Aadhaar card.
Yes.
Given Aadhaar card to whom?
Dealer.
Dealer Aadhaar card has to verify every time or it is on record?
ନାଇଁ ସେ 7 ଜଣଙ୍କର ଭିତରୁ ସେ କହିଥିଲେ ଆଉ 3 ଜଣଙ୍କର ଆପଣ ଦେଇନାହାନ୍ତି ସେଟା ଦେଲେ ଦେଲା ପରେ ବି ସେ ଆମକୁ ଦେଲେନି ତେଣୁ ଦ୍ୟାଟ
ଆରେ କୋଉଠି ଦେଲେ ସାର୍ ମୁଁ କ୍ୱେଶ୍ଚନ ଇଜ ଡିଫରେଣ୍ଟ ଆପଣ ଯୋଉ ଦେଇନାହାନ୍ତି କାହାକୁ ଦିଆ ହେଇଥିଲା 4 ଜଣଙ୍କର
ଡିଲରଙ୍କୁ ଦିଆ ହେଇଥିଲା
କୋର୍ଟ ଲେକ୍ଚର
ସେ ଆଜ୍ଞା ପାଉଥିଲେ ପରା
ସେ ଆପଣ ଆଧାର କାର୍ଡ କେମିତି ପାଇବେ ମୁଁ
ନାଇଁ ନାଇଁ ସେ ରାସନ କମୋଡିଟି ପାଉଥିଲେ already
ସେଟା sir that is not that we are not discussing whether they were getting it or not after much prodding you have told me that due to non-submission of Aadhaar card to the dealer, he is not giving ration to 3 persons. I am telling you under which provision you have to give the Aadhaar card to the dealer. Is it a one-time measure or every time you go and get the ration card? Ration food. You have to show the Aadhaar card. Your answer is that
dealer said to the petitioner it is mandatory for the
every time.
Mandatory that you have to submit your Aadhaar card before the dealer. If there is required.
So provision dekhantu.
Thereafter, petitioner grievance.
Sir, you know so many things. I do not know. I have to inquire from you. You have to assist me. Under which provision the dealer seeks for production of Aadhaar card, and you have given it for 4. Where is that? Because unless you show that, then how the court will direct that there is a provision, notification, circular, and you are producing the Aadhaar card, so why he is not giving. But your own case is that you never produced for 3 persons. But after delay, maybe thereafter you have produced. But the dealer is not responding.
But prior to that,
and also with the authority you are not very sure or clear, because I have been asking you whether you give it to the dealer or the civil supply officer or the inspector, because usually these things are not to be maintained at the dealer end. This has to be maintained in the office. Some database has to be there.
But they are
because how a control dealer, this fair price shop owner, how he will store this data? These are all digital data. How he will have access to this data? You are issued a authenticated card with all data. You show the card to the person, dealer. He is a humble shopkeeper. He only has a special license, fair price shop, a PS license. So how he will verify and store this data? Suppose he's catering to 100 people in a village. Each family, suppose like your family, 7 persons, 15 families comes to 100. In Orissa, very few villages are there where there will be 15 families.
Your Lordship, out of 7%,
So that I have got it, but you are not relying on, you are not showing me some provision where this is to be done, how it is to be done rather.
ସେ ଡିଲାପ କହିଲେ ସେଟା ଆପଣଙ୍କର ଆଧାର କାର୍ଡଟା ଯେହେତୁ ଆପଣ ଦେଇନାହାନ୍ତି ସେଟା
ସେଟା ଆପଣ ମତେ ତ 4-5 ଥର କହିଲେଣି.
ଲିଙ୍କ
I
କରିନାହାନ୍ତି
think I have understood that. All the people agree that I have understood. But I am going one step ahead, that under which provision, what is the procedure followed for production of this Aadhaar card? Who is the authority to accept that and say that yes, you are going to? It could be, as you are saying, could be the dealer, but the difficult part is how a dealer will maintain all this data, or every time you go and show the Aadhaar card, then they will give. I do not know. Your petition doesn't make help me to understand this.
It was for
So
final.
my submissions are final hearing. You have to give me those details so that I can hear it finally.
Your Lordship,
For final hearing, sir.
it was for your Lordship for final disposal.
Correct, sir.
So I have given the written submission of.
Written submission without substance pleadings, how it will help you? It has to be there in the
Your
pleadings.
Lordship,
Because your writ petition should not be 12 pages. Your writ petition should be a maximum a 2-page writ petition, affidavit another part. That this is the provision, this is the, dealer is to do this and has not done this. So a petition, while I have stated regarding the procedure to be adopted for distribution of fair price sub-commodity.
2 weeks time to.
So, 2 weeks time पर कौन होगा?
I will.
Petition तो जहाँ थला से रहेगा ना नहीं. The learned counsel for the petitioner was heard at some length. The learned counsel The learned counsel has adjournment to address the court regarding the provisions under which the petitioners in the writ petition who are claiming fair price commodities under the ଆପଣ ତ କିଛି ଦେଇ ବି ନାହାନ୍ତି, ଆପଣ ଖାଲି ଗ୍ରିଭାନ୍ସ ପିଟିସନ ସବୁ ଏନକ୍ଲୋଜ କରୁଛନ୍ତି. ଗ୍ରିଭାନ୍ସ ପିଟିସନ ରୁ କଣ ବୁଝି ହବ? କିଛି ବୁଝି ହବନି. ଆପଣ ସେଟା ଫ୍ୟାକ୍ଟ କହିବେ. That is how your petition runs to 12 pages, annexures, but I can hardly understand with my whatever limited I cannot understand what is there. कौन लिख ले? Last slide. Under the public distribution system, he shall bring before the court the details of procedure that is to be adopted for giving the fair price commodities. ऊपर फर्स्ट लाइन लिखी हुई जो हार्ड एट पूर्व लिखी, द मैटर इज लिस्टेड फॉर एडमिशन हियर. तापर एटा लिखी. तापर लिखले हार्ड जो लिखले तापर लिखियो इट इज सबमिटेड बाय द लर्नड काउंसिल फॉर द पिटिशनर दैट द पिटिशनर्स family is of 7 members. Stop. Out of them, 4 members have given fair price commodities in the public distribution system, and 3 have been denied. Not denied, and 3 have and the provision of the commodity to 3 members who are the petitioners has been stopped on the ground of they not being produce Aadhaar card. Yes. When do you want, Mr. Hassan?
2 weeks after.
ଆପଣ ପାରା 7 ରେ ଯେତିକି ସେତିକିଟା ଆପଣଙ୍କ ପିଟିସନ ବଟ୍ ତାର ସପୋର୍ଟିଂ ଡକୁମେଣ୍ଟ କାଇଁ କଣ ଆପଣ ଆଧାର କାର୍ଡ କୋଉଠି ଦେଇ ହବ ଆପଣ ଏ ପିଟିସନ ଏଠି ଫାଇଲ କରି ପକେଇକି ରଖିବାର ବି ନଥିଲା on the first date itself in 2024 you should have moved the authority with the Aadhaar card for enclosing your name. That's it. Beyond that, High Court cannot give you fair price commodity.
No, sir,
High Court doesn't know also where it is to be given. Suppose there is a system. Assume, for example, that if you file the Aadhaar card in the registry, it will be done.
Many representation are also given.
Representation will help you, sir. Do you want commodity or representation?
Video.
The representation will be representation will be paper bag. Inside that, you have to put rice, dal, or whatever commodity. How representation will help you? It will not help you. ଯଦି ବି ରିପ୍ରେଜେଣ୍ଟେସନ ଦେବାର ଥିଲା ସେଟା ଫାଷ୍ଟ ଡେ ରେ କାହିଁ ପେଣ୍ଡିଂ କରି ଏଟା କାଉଣ୍ଟର ଫାଇଲ ହେଇକି ଯୋଉ ହିୟରିଂ ପାଇଁ ଆଜି ଆସିଲା we are making an effort or not that to that extent you should be satisfied that you have addressed. I have tried to understand though Mr. Sahoo is not asked but what he will say because what is your pleadings in this petition he will only answer that.
One thing Miller I may point out sir.
Please.
Under 9, 10, 11 actual things Miller he has been asked to take whatever his quota was tagged but he has deliberately not lifted and he has also by document by letter asked to add those by online application he has also not done. So all these are factual things he has been asked twice.
Now Mr. Hassan then what they will do?
Everything has been also given.
ଲେଖିକି ବି ପଞ୍ଚାୟତ ଅଫିସରୁ ତାଙ୍କୁ ଚିଠି କଲେ
ଆଜ୍ଞା ସବୁ ଦେଇ
ଆରେ କୋଉଠି ଦେଇଛନ୍ତି ଆପଣ ଅନଲାଇନ ସିଷ୍ଟମରେ ଆପଣ ଆପ୍ଲାଏ କରି ଦେଇଛନ୍ତି ମାନେ କଣ ମୁଁ କହିବି ତାଙ୍କୁ ଦିଅନ୍ତୁ ବୋଲି ଆପଣ ଯଦି ରିଜେଣ୍ଡର ଫାଇଲ କରିବେ ଯେ ଅମକ ଦିନ I had applied online para 8, 9, 10 counter ରେ ସେ ଲେଖିଲେ that he has been requested to lift the amount. He has been requested to file online application and update the data. So what would be your answer in rejoinder? On 12th December 2025, it is an example. I had applied online. This is the counter form, application form. जोटा डाउनलोड हुए तापर मिले जोटा सरला अपन एठी आसी यू आर जस्ट सिंपली सेइंग आगे सबु देइछु आगे सबु देइछु तो आई मीन दैट लीड्स टू नोवेयर. Did you ask your client that in response to what would be the response to para 8, 9, 10 of counter?
Yes.
आगे
2 weeks time
simply denial.
अपन लिखंतु these matters are not to be kept, Mr. Hassan. This will not yield any result. It will not yield any result. This is more kind of an administrative action where your participation is necessary. When your clients participate, they don't participate, they don't do, they cannot do because gone are those days when one signature will do everything. Now there is identity proof. They are going for even retina imaging, biometrics. There was no 5 rupee or 2 rupees rice, 5 rupee meal. The whole this delivery mechanism of welfare schemes has changed. That there is now more consent, more thrust on food delivery of food directly. Delivery.
earlier
Fair price commodity. If you do not apply, you should have taken that stand that yes, even if I have not applied, I will apply now. Would have taken that order from the court.
Also, earlier the petitioner was getting ration commodity.
That you have said for the 10th time. I have heard for the 10th time and I am sure I have understood it. They were getting and they were denied because of non-production of Aadhaar card. I have dictated also.
You kindly pass any of.
What order I will pass? You want to apply in terms of para 8, 9, 10?
Release the ration commodity.
No. That I will do if you come to my house. Whatever capacity 1 kg, half kg, I will give you. But I cannot direct Mr. Sahoo that you give or Mr. Sethi, they will go to Supreme Court. That this judge doesn't understand anything of law. Even if we have taken a stand that we have asking him, requesting him to apply, he is not applying, but judge says that you give him. ଆପଣ ଟିକେ ପାରାଟା ଦେଖନ୍ତୁ ଟିକେ କାଉଣ୍ଟର ଆପଣ ଏଟା ରଖନ୍ତୁନି ଇଟ୍ ୱିଲ୍ ନଟ୍ yield you any result କାହିଁକି ମତେ ଲାଗୁଛି most likely the persons are not responding to you. That is how your submissions are half baked. Because being a lawyer, I also understand the difficulty. Once they do not respond to you, you cannot say anything. You look at kindly read para 5 of counter. Yes, para 5 page 2.
Para 5, your lordship, page 2. That the aberration is made in para 1 of the writ petitioner.
So, chhad diyo. Upon state relevant issue, we have already spent so much of time. Further, it is humbly submitted that 6th, 7th line.
Further, it is humbly submitted that the wife of the petitioner, namely Dolly Das, has been issued notice from the Block Development Office, Marsa, dated so-and-so, and other letter dated so-and-so, to receive PDS entitlement from the month from July 2019 to January 2020. But she has neither received the PDS entitlement nor given any reply for the same.
Tapare paduntu.
That with regard to the aberration made in para 2 and 3 of the writ petition.
So they have enclosed that those letters, copies of letter date 4/12/19 and 21/2/20. So they have enclosed those letters. Now kindly read 7.
Then in reply to the aberration made in para 4 of the aforesaid writ petition is humbly submitted that there are 7 members in the ration card bearing number. And so initially, but at present there are only 4 members in the ration card. This due to non-submission of other 3 members up to 7 members by the ration card holder, which has resulted in the deletion of 3 members from the ration card as per the record and file available in block office.
Read slowly that portion. That is the crux. As per the record and file available, so to slowly put on.
This is due to non-submission of other of 3 members out of 7 members by the ration card holder, which has resulted in the deletion of 3 members from the ration card.
Yes.
As per the record and file available in the block office, it is revealed from the letter number 5216 dated 17/11/2020 of then BDO Marsagi addressed to the CSO Kendrapara the deletion movement of 3 members who suspect 6 of 3 members from the ration card was due to non-submission of the necessary Aadhaar by the family for necessary seeding or validation in the ration card. Hence, the aberration made in the aforesaid paragraph are totally false and fabricated.
ଆପଣ ଡଲି ଦାସଙ୍କ ଛଡା ଆଉ କିଏ ଅଛନ୍ତି ଏଥିରେ ପିଟିସନର ନା ଡଲି ଦାସ ପିଟିସନର ନୁହନ୍ତି
ହଜବେଣ୍ଡ ଅଛନ୍ତି ରବୀନ୍ଦ୍ର ଦାସ
ସିଏ ରବୀନ୍ଦ୍ର ପାଉଛନ୍ତି ନା ପାଉନାହାନ୍ତି
4 ଜଣ ଆଜ୍ଞା
ଆରେ ନାଁଟା କୁହନ୍ତୁ ସାର୍ ମୁଁ ଆପଣ ଯଦି 4 ଜଣ କହିବେ ମୁଁ କଣ ବୁଝିବି ରବୀନ୍ଦ୍ର ଦାସ ଡଲି ଦାସ ଏବେ ପାଉଛନ୍ତି ନା ପାଉନାହାନ୍ତି
ଏବେ ପାଉନାହାନ୍ତି ଆଜ୍ଞା
ଡଲି ଦାସଙ୍କୁ ସେ କହୁଛନ୍ତି ନିଅନ୍ତୁ ଆପଣ ସେ ଦଉନାହାନ୍ତି ଠିକ ଅଛି ବାକି ଅନ୍ୟମାନଙ୍କର କଣ ରବୀନ୍ଦ୍ର ଦାସ ଡଲି ଦାସ ଆଉ କିଏ
ତାଙ୍କ ପିଲା ଆଜ୍ଞା
ତାଙ୍କର ଚିଲଡ୍ରେନ୍
ପାରା 10-11 ରେ ଆକ୍ଚୁଆଲ ଗୁଡା ସବୁ
ଦେଖନ୍ତୁ
ଚର୍ଚ୍ଚା ହେଉଛି ସେ ନଉନି
ପାରା 10 ପଢନ୍ତୁ
ପାରା 10 ପଢନ୍ତୁ 11 ତାପରେ ସବୁ ଗୁଡା ଅଛି ଫ୍ୟାକ୍ଟ
Para 10 lordship that in reply to the aberration made in para 7 of the aforesaid it is humbly submitted that the complainant petition filed by the petitioner on dated 29/2024 is baseless and the head of the family, that is Dolly Das, the wife of the petitioner Ravinder Das, has been intimated by the PDO by White Office letter dated to receive the monthly entitlements both under normal NFSA and PMJKY free of cost by speed post. Moreover, the present PDO had addressed the issue and informed the petitioner White memo number so-and-so, wherein the petitioner was advised to lift his monthly entitlement of food grains from the tag fair price for retailers. That effort he has been advised by the first letter to supply online for necessary addition of other deleted family members in the existing ration card.
So that closes the chapter, Mr. They are not interested. I don't think there is some other thing beyond this. This is not even a storm in the teacup. I'm disposing it off so that you will be at least relieved. Para 10 and definitely order cannot be passed against you dismissing your writ petition, because what has happened here? They concede to your prayer of giving you PDS. They don't dispute that. They say Dolly the family was issued letter. Second thing, they have issued speed post letter, maybe due to filing of writ application, that NFSA and PMJKY free you are entitled to receive. Then apply online, they have requested you. You respond to that. Clear? Yes, provision of the coverage.
On the ground of they have not been addressed to produce identity.
Yes. ତାପରେ ଯୋଉଟା ପ୍ରଥମ ଡାକ୍ତରୀ ସେଟା କାଟି ଦିଅନ୍ତୁ ତା ପୂର୍ବଟା ଆଟ୍ ଲେଟ୍ ସମ୍ ନୋ ସଫିସିଏଣ୍ଟ ତାପରେ କାଟି ଦିଅ In response, the Lord Additional Standing Counsel refers to the counter affidavit filed by the opposite party number 3 authority, that is Block Development Officer Marsagai. He refers to paragraph 5 of the counter. Stop. The relevant portion of the paragraph 5 is reproduced herein. Further, it is humbly submitted through Neki. Para 5 page 2 re achi. Within quote. Annex of B/3 portion. Hela. Para. Further, it is evident from the counter that the authorities also have stated that the reason of deletion of 3 persons from the beneficiary list of PDS commodity was due to non-submission of Aadhaar card. Non-submission their Aadhaar card. है ना? देखिए पढ़ा से For adjudication of the present writ application, the significant aspect has been mentioned in paragraph 10 of the counter affidavit, and the relevant portion of the said affidavit is reproduced here. 10 and 11. Ten or 11 reproduce कर दियो. In view of the amendments made in the counter affidavit on behalf of the BDO, the writ application is disposed of, directing that the petitioner shall receive, the petitioner Dolly Das shall receive the PDS commodity as indicated in the counter affidavit paragraph 10 above.
Page 16 is the card. Card we have said 4 numbers. That is also we have given.
The petitioner shall also, petitioner into bracket small s, shall also take steps as indicated in the counter affidavit that they shall submit requisite documents for addition of their name in the ration card. It is further directed that the authorities shall render all assistance and necessary help to the intending applicants for inclusion of their name in the ration card. The writ petition is disposed of accordingly. Yes.
Right.
But don't expect an order like this that court will direct give them ration. That is not possible. Yes, yes.
Okay.
I'm appearing for a wife estimate.
Yes, Mr. Gonak.
The reviewers challenge the legality and correctness of the order of Judge Family Court Puri on 4 counts, mainly that the wife is failed to abhor and prove that she is unable to maintain herself. Second thing is he is willful deserted. Third thing is that the Lord Family Court passed an order in favor of a child. At the time he was
Favor of the child? Mr. Gonak, the difficulty in this, VC hearing. Certain words you will speak, I will not be able to hear, and you will not be able to hear me also. Yes?
Lord of Family passed an order in favor of a child. At the time of application, the child was in the mother's womb.
So the child derives nutrition through the amniotic barrier. So that is not an issue. That cannot be argued. The nutritional food that mother has to take.
At the time of application, he was mother's womb. How can the petitioner prove
Sir,
that?
at the time of order.
At the time of order, she was in mother's womb. No, at the time of she was born, there is no pleading.
So you show some citation on this.
That's
that the mother in the family way cannot claim the expected the delivery of the child and the maintenance.
Maintenance. That the
Don't give hilarious proposition in court without any supporting document or any provision or the case law.
That the statute provides that the 125 says if any person having sufficient means neglects or refuses to maintain his legitimate mind child.
125 पढ़न्तु नहीं आएगा. अरे your facts are different. If you look at if you look at the petition then. भाभी की argument करा जाएनी. You don't build a castle in the air.
No, sir. The petition kind preludes the prayer. The anti-prayer on the circumstances, page 25. On the circumstances, the petition's prayer.
The petition the child in the page 12 देखंतु. तापर कौन असुविधा है?
सेटा सर at the time of womb.
अरे at the time of कौन केते थर गोटे कथा कहिबे आपनकर कौन 9 month gestation period तापर premature baby ओडा डिस्कशन होबो ना कौन?
नहीं
आपण टिके पिटिशन कॉस्ट टाइटल ता देखंतु. पेज 12 को उल्टोचंदी सेते बेला आपनकर मिलुनी आपण गोटे पेज मिलुनी आपण.
कॉस्ट टाइटल केवल रहिला ओनली मदर सर.
So how does it matter if she gives a birth to the child? That is the question asked to you.
My commission before this court is that when the child is not born, the petition has not proved.
कहउचंदी आपण सेटा काहे की कहउचंती बेसिस कोन तार कहबार.
Basis कहयार जे
after the child is born to the mother out of the wedlock from the wedlock, how can you argue this? Don't waste your time, sir, in making absolute outlandish proposition.
That the language speak that he must prove that the child is to neglected by his father.
Ordering portion ता पढंतु.
Sir,
आपण जो सेक्शन पढुचंती भूल पढुचंती.
नहीं सर सेक्शन सर
आपण 125 पेज जहाँ अच्छी 12 रो cost title satisfies that. Page 12. Now read the order.
The order 20, the petition on 125 is filed by the petitioner allowed on contest against the OP. The OP is directed to pay 2,000 per month to petitioner and her child from the date of application, that is 12/4/2023. subsequently, in execution cases, on that day, 10/12/2025, the London Family Court.
ଆରେ ଆପଣ ପୁରାଟା ପଢୁଛନ୍ତି ଗପୁଛନ୍ତି ଓଡ଼ିଆରେ ପୁରା ଅର୍ଡରଟା ତ ପଢିଲେନି ତିନି ଲାଇନ ପଢିଲେ 10 ଲାଇନରୁ ତାପରେ ଗପିବା ଆରମ୍ଭ କଲେ
Since both the
leave
parties
these habits sir leave these habits of complete lack of concentration ପଢନ୍ତୁ
Since both the parties have not disclosed anywhere if the child of the parties is a girl or boy, the child of the petitioner is entitled to get maintenance till he or she attains the majority. The arrears of maintenance due should be paid within 3 months from the date of this order, and the incurring maintenance due each month to be paid in first week subsequent month.
so what is the mistake
My submission is
ଆପଣ ସବମିଶନ ବହୁତ ଥର କହିଲେଣି ଆପଣଙ୍କର ପିଟିସନର ହେଲେ ମଦର
sir.
ଯେତେବେଳେ ଆୱାର ହେଲା ସେତେବେଳେ ତାଙ୍କର ଛୁଆ ହେଇଥିଲା ସୋ ଆପଣ କହୁଛନ୍ତି ଯେ ସେ ଛୁଆର ଆପ୍ଲିକେସନ ଦିନ ଆପଣଙ୍କର ଧରନ୍ତୁ ଛୁଆଟା ଜନ୍ମ ହେଇଥାନ୍ତା ଯୋଉଦିନ ଆପ୍ଲିକେସନ ଦିଆହେଲା କ୍ୟାନ୍ ସି ଫାଇଲ୍ ଆନ୍ ଆପ୍ଲିକେସନ ଅର୍ ଇଟ୍ ୱିଲ୍ ବି ରିପ୍ରେଜେଣ୍ଟେଡ୍ ବାଇ ଦ ମଦର
On the date of application, he is not born.
So who says that the child was born? The court doesn't say so.
It should be the petitioner should state that when he is born.
Is she your wife or your client's wife?
Client's wife.
Then why you are talking like this?
Yes, sir.
You should use proper language in the court.
This is the position.
And the court has said that the child was born and that is how to be given maintenance. You are adding these lines to the judgment. See, the child is not the petitioner, the child cannot be. Second aspect, if the child is born and the court has taken cognizance of that, then what is wrong there? You have to make a provision that in a 125 pending proceeding or a 24 proceeding, if a child is born, the child cannot be given maintenance. You are just arguing the reverse.
The judgment not only discuss that when she has born. The judgment remains silent.
Sir, the problem is that you are not disputing that the child is born. You are only disputing that on the date of, you are saying, on the date of application, the child was not born.
Sir.
So then why you are going on harping on that?
Now, my assumption is total the legality and correctness of the order of the judgment of the family court Puri. On more, this is the four count.
Very overconfident.
Sir. Now the second first question is the wife is failed.
So Godnaik, stop talking, blabbering. Read the para 8 of the judgment. You have made a joke of this proceeding. One question you cannot answer, that where is the prohibition of a child if born during pendency of application not to be added. That you are struggling. He was not born. Who is saying that he was born at the time of filing the petition? Has the court said so? Read para 8.
Sir, the OPS pleaded that he is always ready to accept the petitioner, but she is not willing to stay with him. PW1 stated that
Slowly पढ़ंतु आपण we are missing words also. Slowly पढ़ंतु आपण capability अनुसार पढ़ंतु.
PW1 stated in cross-examination that if her husband wants to take her to her matrimonial home, she does not want to return her matrimonial home. PW1 in answer to the questions put by court, she stated that her husband has suspected her character and the paternity of her child was challenged by her husband. Further, the OP did not keep any contact with the petitioner after getting the information about her pregnancy.
So now you got the answer. Have you got the answer which you are blabbering since arguing? That is her case. When she was pregnant, she was driven out.
Sir. No, sir.
She has never said that the child was. Now you are saying so. You are making a mess of a case. Then kindly read further.
I am arguing that.
Sir, you read. Then you read the. You are not to argue. You have to read the judgment to understand it.
I understand that.
Sir, kindly read.
Sir, this question is put by court 165.
Judgment complete करंतु आज्ञा.
Sir, for that reason, the petition is not willing to return to her maternal home. The petition has not filed any criminal cases against the OP for its ill treatment. It cannot be expected from wife to lodge a complaint before any forum when the paternity of a child has been challenged by her husband. The above proceedings of PW1 show that she has not voluntarily rejected the society of OP without reasonable cause.
ତାପରେ ପଢନ୍ତୁ ଆପଣ ସରିଗଲା ପାରା 6 ପାରା 9 ଯୋଉଟା
PW stated that PW1 stated that the OP is working as a driver at Paradip Port and he is earning 60,000 per month. The father of petitioner also supported the evidence of the PW1 regarding source of income of the OP. PW number 1 in construction at paragraph 930 stated that she has no direct knowledge about the income of her husband, but her husband has disclosed about this income before his family members. The father of the petitioner also admitted that he has no direct knowledge about the income of the
When you get answer also.
but the OP was working at Paradip Port. The OPW1 stated that after some months of the birth of his child, he and his family members had gone to the parental house of petitioner and noticed that the petitioner was doing tuition of 10 to 15 children. He further declared that his old and ailing parents and one disabled elder brother and his wife are depending upon him. As for the evidence of the OPW1 from the petitioner, he came.
ସେ ଆପଣ ଗ୍ଲସ୍ ଓଭର କରିବେନି ବୋଧେ
Sir,
you look to be smart maybe Mr. Garnack OPW1 stated that
as per the evidence of OPW1 from the petitioner, he came to know that he had got.
अरे सेटा पढन्तुनी आज्ञा भूल भाल पढुचंती मु जोटा आपन कहली स्लोली पढन्तु सेटा पढन्तु OPW1 stated that after
He came to know that she has got the training in manufacturing handicraft items from the local SAG prior to her marriage.
ए याडे अनंत आपन आपन डिसोरिएंटेड हे गेलेनी पेज 19 धरचंती
Sir,
internal page 8 of the judgment
sir,
6th line down
OPW stated that after.
हां सेटा OPW के
OPW husband.
आपन ताको वकील
Sir,
आपन महकिल कोन कहले पढन्तु
sir,
आपनकर महकिल कोर्ट रे कोन कहिले पढन्तु
stated that after some months of the birth of his child.
सेटा कोन रोहंतु सेठी
Sir,
सेटा कहार स्टेटमेंट आपन स्टेटमेंट
sir,
कोन डिस्प्यूट कोन करचंती आपन
dispute टा हमर गोटी सिंगुलर सर कहूची सर से dispute
सिंगुलर आपन बहुत थोर कहली सेटा आपन बदे भाबिचंती कोठो आपन का कंसल्ट करनांती कि वेरीफाई करनांती आपन आपन निजे स्टेटमेंट देचंती कोर्ट रे जे आपन कर पिला जन्म होला पर आपन वैल्यू का को से छुआ को पढुतिले या तो कहचंती कोन सो दैट इज एनफ
नहीं माई
सेटा आपन जे सेटा 125 पिटिशन फाइल होला बडे छुआ जन्म नथिला दैट विल बी रिकॉर्डेड सर दैट विल बी रिकॉर्डेड एंड आंसर तापर अन्य कोन ता छडा सेकंड पॉइंट को असंतु
second point sir asala the petitioner wife has not go and prove that she is unable to maintain herself while the in a rejoinder of husband she stated that petitioner is
सेटा 125 रे देखंतु प्रोविजन सेटा नाही
sir अछि sir
पढिबेन तो से प्रॉब्लम हो
if any person having sufficient means
गुरु पढौतु नै आज्ञा सीधा जानतु मजिस्ट्रेट अपन
sir the a magistrate on the first class may upon proof of such neglect neglect or refusal
सर सेति होची नेसेसरी इंग्रेडिएंट
sir negligence
आपण जोटा दिस इज ए नेचर ऑफ दिस इज ए वेलफेयर मेजर
sir
शी हैज टू प्रूव दैट देयर इज नेग्लेक्ट आपण जोटा प्रूव करिया कथा चाहउछंती कुड हैव क्रॉस एग्जामिन्ड
sir
आपण क्रॉस एग्जामिनेशन किछि नाही दैट शी इज कैपेबल
sir totally
आपण 15 जन पिला का ट्यूशन कथा कहउछंती सेति पई
नहीं सर सर मु सर इट कहछि ना मु
थर्ड पॉइंट को असंतु
my question my submission before this I have never neglected I am ready to take
हां ठीक अछि आपण को रेडीनेस हला ठीक अछि सेते रेडीनेस कोठी नाही 125 रे 125 रे प्रोवाइड जो ऐड करू तुमी प्रोवाइडेड दैट द हस्बैंड इज रेडी टू टेक आई कैन ना रिफ्यूजल थर्ड पॉइंट को असंतु
सर रिफ्यूजल मिट सर करूनी सर का इंटेंशन लेजिस्लेटर सदा से देखिबे कारण एमती 2007 से ओडिसा हाई कोर्ट डिसीजन अछि ओडिसा हाई कोर्ट डिसीजन साथ हम कहूची तेथि सर क्लारिफाई कला ओएलआर 2007 वॉल्यूम 1
अपन एगा सर तो सेंती डोंट ब्लैबरिंग समथिंग इन द कोर्ट अपन थर्ड पॉइंट को असंतु लास्ट साइटेशन को जिबे
सर थर्ड पॉइंट जी हला he has not complied the Rajneesh Neha to file his asset and liability in
ରଜନୀଶ ନାୟକରେ କୋଉଠି ଆର୍ଟିକଲ 125 ଦେଖାନ୍ତୁ
ସେଟା ସେ କହିଲା all maintenance sir କହିଲା sir
ଦେଖନ୍ତୁ
page sir ସେ କହିଲା page 606 final direction under article 140 constitution payment of intervention the affidavit of disclosure of assets liability annexed as enclosure 1 2 3 of this judgment as may be applicable shall be filed both the parties in all maintenance proceeding including pending proceeding before the concerned family court district court as case
ତାପରେ ଆପଣ ଆଡ୍ କଲେ ନା if not filed then no maintenance can be granted ସେଇଟା ପଢିବେ
ତ ସେ ଏଇଟା ତ ଡିରେକ୍ସନ ହେଲା ସାର୍ ସମଥିଙ୍ଗ ସାର୍
ଡିରେକ୍ସନ ହେଲା ସାର୍ ମୁଁ ସାର୍ କରିପାରିବିନି ସାର୍ I cannot watch two lines to the Supreme Court judgment by Rajneesh versus Neha. Even the Supreme Court judgment is an honorable judgment.
Sir.
So purposefully the Supreme Court has not said that it will not be awarded if no affidavit is filed. Because the court makes a award of 3,000, 2,000. So you must understand that.
Sir.
I cannot do that.
Sir.
If the Supreme Court has put a bar, it is a bar. If it is not a bar, then it cannot be a bar by interpretation. Cannot be.
142 article is directed.
Yes. So 142 article there is no direction that our maintenance award cannot be made if affidavit is not filed. 125. Even though what you are reading, you are only reading partly. Supreme Court is discussing regarding section 25 award, permanent alimony.
Sir, I am apart from this.
Trying to read para 10. Para 10 of the judgment.
Para 10 is available now.
କଣ ହେଲା
Para 10 judgment is available sir.
ଆଜ୍ଞା
Para 10 judgment is ଆଣିନି sir କେବଳ total ରଜେଶ ନେ total judgment ଟା sir ଆଣିନି କେବଳ
ରଜନୀଶ ନେ ଆଣିନାହାନ୍ତି ଦୋକାନ ମୋ ପାଖରେ ଅଛି ଆପଣ para 10 ଯୋଉଟା ଆପଣ ଇମ୍ପ୍ୟୁନ୍ କରୁଛନ୍ତି ସେଇଟା ପଢନ୍ତୁ
sir. So para 10 no?
ଆପଣ ଯୋଉଟା ବର୍ତ୍ତମାନ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି ହାଇକୋର୍ଟରେ ତାର 10 ଟା ପଢନ୍ତୁ
para 10 sir କିଛି ନାହିଁ sir
ଅଛି ସାର୍ ଇଣ୍ଟରନାଲ ପେଜ 8 ଅଛି para 10 ଅଛି ରନିଂ ପେଜ 19 ଅଛି ସାର୍ ଅଛି
sir sir in this case petitioner has not filed
only ପଢନ୍ତୁ ଆପଣ ଯେତେ ଫାଷ୍ଟ ଯାଉଛନ୍ତି ସେଥିପାଇଁ ରେଜିଷ୍ଟର ହଉନି ଆପଣ ନିଜର ଭାଇଟାଲ ଏଭିଡେନ୍ସ କୁ ମିସ୍ କରିଗଲେ
sir in this case the petitioner has not filed the affidavit of assets and liability but the OP has filed the same the OP disclosed in the affidavit of assets and liability in this occupational farmers
ଶୁଣନ୍ତୁ ତାପରେ ରଜନୀଶ versus ନ୍ୟାୟ ହେଲା ଆପଣ ଯଦି ଏବେ ପି ନବାର ଥିଲା ସେଟା ଫାଇଲ କରି ନଥାନ୍ତେ ତାପରେ ପଢନ୍ତୁ
sir the OP disclosed in the affidavit of assets and liability that is the occupational farmer and he is earning less than 1,000 per month. What is noticed there? Column B of the affidavit assets and liability, the OP is remain blank. There is no evidence to hold that the OP is not an able-bodied person. It is admitted by OP that child who was in the womb of the petitioner has already born.
Sita Batan, that answers your lengthy 5-6 times averment that child was not born. 125 was filed. The court is conscious of that.
Sir.
ଯଦି କୋର୍ଟ ଯଦି ଗୋଟେ ଅନବର୍ନ ଚାଇଲ୍ଡ ଦେଇଥାନ୍ତେ ବି ତାହେଲେ ଆଉ ଗୋଟେ ଜିନିଷ ଇନିशियली I was thinking that the court has given to unborn child then kindly read further
the court's order person sir ठीक है it is admitted OP that child learning counsel of the petitioner has relied upon the finding of Hon'Ble High Court in the case of Santosh Kumar Torai versus Sahoo reported 2018 to ILR Kotak 271 Sanghamitra Mahana versus Balaram Mahana and Anand reported 2019 Volume 3, ILR Kotak 197, and the Sanjeev Kumar Parida versus Sukanti Das reported in its 2019 1 ILR Kotak 409 in view of the above discussion, the OP is directed to pay maintenance amount of 2,000 per month to petitioner and her child. That is 4,000 in total from the date of application on 12/4/2023. Sir,
Yes.
my
So now, Mr. Gondak, since you have so much relied on that, so first question, so you should be satisfied that first question is not to be, your proposition is not correct. The problem is the court has itself considered the child was not born when the petition was filed. The child was later born.
Sir.
You yourself have stated, your client has stated that when he went visit his wife,
Sir.
ex-wife, whatever,
Sir.
child was born.
Sir.
Then there is a presumption. Those things should not be gone into actually in a 125 proceeding. The presumption of patronage of a child is legally sanctified by the Evidence Act also.
Sir.
Rajnish versus Neha, what you are saying, you have filed yourself affidavit. If you would not have filed affidavit, then now you have to show that on the basis of affidavit, 2,000 is a bad amount. That is the problem. A wrong amount, not bad amount, wrong amount.
Sir, at kind of tell you at flag B. At flag B. On dated 10/12/2025.
ଆପଣ ଯେହେତୁ ରଜନୀଶ ଆଣିନାହାନ୍ତି ମୁଁ ବାହାର କରୁଛି ଆଉ କଣ କରିବି ଆପଣ କାମ ହିଁ କରୁଛି କରନ୍ତୁ ଆପଣ ପଢନ୍ତୁ
ଫ୍ଲାଗ ବି ଟା ସାର୍ ଟିକେ ଦେଖିବେ ଫ୍ଲାଗ ବି ରେ ସାର୍ ଦେଖିବେ 10/12/2025 ରେ my submissions before this torrent code already rectified and allowed in part. Flag B ଟା ସାର୍ ଦେଖନ୍ତୁ 10/12/2025 order ରେ the record is brought from the record room since some error has been noticed in the judgment during the hearing in the connective criminal execution case number 20/2025. Result the copy of the judgment passed in this case.
এটা ଆପଣ ମାର୍କ କଲେନି ବୋଧେ ମୁଁ ଆପଣଙ୍କୁ ପଢିବା ପାଇଁ କହିଥିଲି
ସାର୍
ଆପଣ ସେଇଟା ଯେତେବେଳେ କୋର୍ଟ ଆପଣଙ୍କୁ କଣ କହୁଛନ୍ତି ପଢିବା ପାଇଁ ଆପଣ ସେଇଟା ମାର୍କ କଲେନି ଆପଣଙ୍କୁ ମୁଁ ଅପରେଟିଭ ପୋର୍ସନ ଟା କହିଥିଲି ପଢିବା ପାଇଁ ଆଇ ଗେଭ୍ ୟୁ ହିଣ୍ଟ ଅଲସୋ
ସାର୍ ଏଇଟା ଫ୍ଲାଗ ବିଟା ସବସିକ୍ୱେଣ୍ଟ ସାର୍ ହେଇଛି 10/12
ଆରେ ଫ୍ଲାଗ ବି ନୋ ଅପରେଟିଭ ପୋର୍ସନ ଦେଖନ୍ତୁ ଆପଣ ଯେତେବେଳେ ଅନବର୍ନ ଚାଇଲ୍ଡ କଥା କହୁଥିଲେ ସୋ ଦ୍ୟାଟ ଇଜ ଦ ପଏଣ୍ଟ ସୋ ଇଟ ଇଜ ଫ୍ରମ ଦ ଡେଟ୍ ଅଫ ଦ ଅର୍ଡର
ହଁ ସାର୍
So ସେଇଟା ଆପଣ if you go back you now realize what I pointed you out.
ନାଇଁ ସେ already rectified from the date of
ସେଇଟା ତ ଅଲଗା କଥା ସେଇଟା ଆପଣ ପ୍ରେୟାର କରିଥିଲେ ହେଇଥାନ୍ତା ଆପଣ କଣ କଲେ ସେଇଟା ତ ସେଠି କଲେ ସେ କରିଦେଲେ so that point in your so that I was pointing I had pointed you out that read the operative portion of the order. Operative portion regarding the child says from the date of application but now it has been done from the date of order. The date of order you yourself you are saying the child is born. The amount is 2,000. Now you have to argue, suppose, possibly, Rajnish versus applying Rajnish versus Neha test, the amount of 2,000 is not also there or higher, not there in the, I mean, it cannot be justified.
Sir, my submission is one word, would the leave out. When the child, how the petitioner has proved the child negligence and refusal of his father?
Say upon proof of negligence is sufficient. This is not a first appellate court. I am not appraising evidence again. ଆପଣଙ୍କର ଯାହା evidence ଅଛି that is enough.
There is no negligence.
ଆପଣ ଏଥିରେ ଆପଣଙ୍କର trial ହେଇକି ହଉନି because it is a maintenance is in the interim nature. It is not a section 25. So if you have cross-examined the lady straight away you should have taken those ground. That is not there.
Sir, already have ଆପଣ
ଏଠି ରିଜେଣ୍ଡର ମୋ ଟ୍ରାଏଲ କଥା ପଡିଛି ଆଜ୍ଞା ଟ୍ରାଏଲ ରେ ଆପଣ କ୍ୱେଶ୍ଚିନ୍ ପଚାରିଥିଲେ କି
ହଁ ସାର୍ ମାଇ କ୍ୱେଶ୍ଚିନ୍ ଇଜ
ହଁ ଦେଖନ୍ତୁ ସେଟା କୋଉଠି ଫାଇଣ୍ଡିଂ ଅଛି ଦେଖନ୍ତୁ
already my rejoinder.
अरे रिजॉइंडर आज्ञा नो सेठी ट्रायल कोर्ट रे रिजॉइंडर किछि फाइल हुए आपण कोठी मटेरियल प्रोड्यूस करथिले एवं आपण कोन प्रोसीजर करथिले आपनकर पिटिशनर कर
It is not suggested that it is not fact that is page 35 para 24. It is not fact that my husband had attempted for several times to take me but I am not willing to return my matrimonial home. It is not fact that I have,
ସେ ତ ଡିନାଇ କଲେ ସେଥିରେ କୋର୍ଟ କଣ କରିବେ?
I have suggested the questions. I
That
have
is
put the
enough.
questions.
That is enough. ଆପଣ ଯଦି ଚାହୁଁଛନ୍ତି ଯେ ସେ ଆପଣ you are earning ଆପଣଙ୍କର ଇଏ ସେ ଜିନିଷଟା you have not neglected ଆପଣ ତାହେଲେ ଶୁଣନ୍ତୁ ସେମିତି କିଛି ନାହିଁ ଯେ ଯୋଉଟା ଆପଣ କହିବେ ସେଟା ଠିକ ଯୋଉଟା ସିଏ କହିବେ ଭୁଲ.
I am already
is that if you have asked these questions ସେଟା ତ ଆପଣଙ୍କର ଡେଜେସନ କଥା କହୁଛନ୍ତି ସେଟା ବି ଆପଣଙ୍କୁ ପଚରା ହେଇନି ଆପଣ କୋଉଠି ଆପଣ ଯୋଉଟା ଏଠି ଆର୍ଗ୍ୟୁ କରୁଛନ୍ତି ଆପଣ ଯୋଉଟା ଏଠି ଆର୍ଗ୍ୟୁ କରୁଛନ୍ତି ଯେ proof of that I have not neglected ସେଟା କୋଉଠି ପଚାରୁଛନ୍ତି ଆପଣ ଡେଜେସନ କଥା ଏବେ ପଢିଲେ
sir
ସେ ରାଜି ହେଇଗଲେ ସେ କହିଲେ my husband has not neglected me ଆପଣଙ୍କର ଏଣ୍ଟା written statement ହଉଛି she has left you because of he says that justifiably.
Sir, court says that the proman element na total intention of legislature 125 speak that she must be proved unable to maintain and refusal of husband.
ସେଟା ଆପଣଙ୍କର ସେ ଯୋଉ proof ଟା ସେଟା ସେ ତାଙ୍କ ଉପରେ ଆପଣ ଯଦି ଚାହୁଁଛନ୍ତି ସେଟା ଆପଣ cross examine କରିଥିଲେ ହେଇଥାନ୍ତା ଯେଟା ଆପଣ ଯାହା କହିଛନ୍ତି that was against you ଆପଣ କହିଛନ୍ତି proof ସେଠି ଥିଲା.
No, it is not a matter that every wife came to court and get
possible. Yes.
No, there is no apex to decisions. 1967 the apex to decisions are
125 ରେ ନୁହଁ ସେଇଟା
sir ଅଛି 125 sir ସେ କହୁଛି sir
ନାଇଁ କେତେ ସାଇଟେସନ କୁହନ୍ତୁ
sir ଅଛି sir
ଆପଣ ଏବେ ରଜନୀଶ ବର୍ସେସ ସ୍ନେହା you get over first ରଜନୀଶ
ବର୍ସେସ ସ୍ନେହାରେ sir ଦେଖିଏ 1975 AR ସୁପ୍ରିମ କୋର୍ଟ 83 ରେ ବି ଲିଖିଛି ରଜନୀଶ ବର୍ସେସ ସ୍ନେହାରେ ରେଫର ହେଇଛି 1975 ସୁପ୍ରିମ କୋର୍ଟ
ନିଜେ ପଢିବେ ନା ଆଉ ନିଜେ ଆପଣ ପଢିବେ ସେଟା ନ ପଢିଲେ କେମିତି ହବ
sir ଭଗବାନ ଦତ୍ତ ବର୍ସେସ କମଲା ଦେବୀ ଆପେକ୍ସ କୋର୍ଟ ହେଲ୍ ଦିଆ
ଆରେ ଟିକେ ସାଇଟେସନ ଟା କୁହନ୍ତୁ ଆଜ୍ଞା ଗପନ୍ତୁନି 75 ସୁପ୍ରିମ କୋର୍ଟ
sir ହଁ 1975 ସୁପ୍ରିମ କୋର୍ଟ पेज 83 sir सेटा sir देला भगवान दत्त वर्सेस कमला देवी apex court held that under 25 clause here is only wife who is unable to maintain herself is entitled to take maintenance.
Yes
sir.
So who says that she is entitled to what the court has held that because she is entitled so upon she has to prove that सेटा कोठी लिखा है नहीं
sir
standard of proof is a trial.
ନାଇଁ sir ସେଇଟା ଲେଖା ହେଇଛି ପରା if any person having sufficient means
अरे ଆପଣ ବହି ନାହିଁ କାଇଁ ଗେସ୍ କରୁଛନ୍ତି when you are not having books I am having all the books so ଆପଣ କାଇଁ ଗେସ୍ କରୁଛନ୍ତି 75 ରେ ଦେଖାନ୍ତୁ କୋଉ ପାରାଗ୍ରାଫ
75 sir ଲେଖିଲା ପରା ଭଗବାନ ଦତ୍ତ versus କମଲା ଦେବୀ
ଆରେ ଲେଖିଲା ପରା କୁହନ୍ତୁନି 75 ଆଜ୍ଞା ପଢନ୍ତୁ I am having 1975 ସୁପ୍ରିମ କୋର୍ଟ
sir ସେଥିରେ ଅଲିଓ ଥିଲା 480 ଆକ୍ଟ ଅଫ 1998 ମେଣ୍ଟେନାନ୍ସ ୱାଇଫ without her income and means can be taken into account.
ସେମିତି ଆଜ୍ଞା କୋର୍ଟରେ ଗପ କରି ଅଭ୍ୟାସ ଛାଡନ୍ତୁ be a responsible lawyer if you are citing a decision read it.
This section doesn't confirm absolute rights on a neglect wife to get.
Para sida straight away come to the page and paragraph of AIR.
That is a letter I will give you.
ନା ସେମିତି ସେ ମୁଁ ଆଜ୍ଞା ଏଠି ମୁଁ ତାହେଲେ ବହି ନେଇ କାହିଁକି ଆସୁଛି
ସାର୍ ଏଇଟା ସାର୍ ଆମେ ଅନଲାଇନ ସାର୍ ଲୋଡ କରିପାରିବେନି ସାର୍ ଅନଲାଇନ ଆମେ ଲୋଡ କରୁଥିଲେ ବହିଟା ସାର୍ ଆଭେଲେବୁଲ ନା ଅନଲାଇନ ସବ ପଢି ସେଇ ପାର୍ଟଟା
ନାଇଁ ସେଟା ବହି ଆଭେଲେବୁଲ ଅଛି ଆପଣଙ୍କର ଏଠି ଯୋଉ ଲାଇବ୍ରେରୀ ଅଛି ସେଇଠି ବି ଅଛି ଆପଣଙ୍କର ପୁରୀରେ ଅଛି
ପୁରୀ ସେ 95 ଆଭେଲେବୁଲ ନାହିଁ ସାର୍
କିନ୍ତୁ ଯେ ଆପଣ ଏପଟେ ପୁରୀରେ ଅଛି ନାହାନ୍ତି ବୋଲି
ସାର୍ ପୁରୀ ସାର୍ ନାହିଁ ସାର୍
ଅଛି ଆଜ୍ଞା ଅଛି AR 75 ସୁପ୍ରିମ କୋର୍ଟ ଅଛି
ମନା କଲେ ଲାଇବ୍ରେରିଆନ ସାର୍ ମୁଁ କଣ କରିବି ସାର୍ ଅନଲାଇନରେ କଲି
ଆପଣ କାହା ଜୁନିୟର
ସାର୍ ମୁଁ କାହା ସେ ଜୁନିୟର ମନୁ ମନସା ପ୍ରାକ୍ଟିସ କରୁଛି
ସାର୍ ସେଇ ଦ୍ୟାଟ୍ ଇଜ ଦ ପ୍ରୋବ୍ଲେମ ସାର୍ କୋଉ ସ୍କୁଲରେ ପଢିଥିଲେ କୋଉ ଲ ସ୍କୁଲ
ବିଶ୍ୱମର ବିଦ୍ୟାପୀଠ
ଆଜ୍ଞା
ବିଶ୍ୱମର ବିଦ୍ୟାପୀଠ ଆଜ୍ଞା
ସେଠି ତ ବହି ଅଛି ସବୁ
ନାଇଁ ସାର୍ ଏଠି ସାର୍ ନାହିଁ ସାର୍
ତାହେଲେ ସେ ସ୍କୁଲ ସେ ବାର କାଉନ୍ସିଲରେ ଲେଖିକି ଦିଅନ୍ତୁ ସେ ତାର ଇଏ ଚାଲିଯିବ ଆପଣଙ୍କ ଲାଇସେନ୍ସ ବି କଟିଯିବ ଥିବ ସେ କଥା
The section does not confer an absolute right on a neglect wife.
Sir, korosi decision kebe second guess karibeni. That is the cardinal principle. ଆପଣ ବହି ପଢିବେନି ଚାମ୍ବର ରେ କାହାକୁ ଜଏନ କରିବେନି ତା ମାନେ ନୁହଁ ଯେ ଆପଣ ଯାହା ନେଇ ଆର୍ଗୁମେଣ୍ଟ କରିବେ କୋଉ ପାରାଗ୍ରାଫ ଭଗବାନ ଦତ୍ତର
ସେଟା ସାର୍ ଅନଲାଇନ ରେ ଆମେ କରୁଥିଲୁ ସେଠି ଲେଖା ଦି sections does not confer an absolute right on a neglect wife to get an order of maintenance against husband nor does it impose an absolute liability on the husband to support her in all circumstances. The
ଆପଣଙ୍କ ଏଗେନ୍ଷ୍ଟ ରେ ମିଷ୍ଟର ଗଡନାୟକ Bhagwan Dutt versus Kamala Devi is against you.
And another judgment is OLR 2007-1-442.
First of all, you distinguish all those 10 judgments of Odisha High Court. Then Bhagwan Dutt is against you, that's another thing. For Podinanti, that may be. Apna trial court re jota judgment site hichi. ठीक अच्छे आपण पढ़ी ना चैम्बर सीनियर को चैम्बर को जानती नहीं सेटा मे बी इट्स भगवान दत्त वर्सेस कमला देवी इज अगेंस्ट यू
सर आउट सर देखिए सर सर आउट सर हम खाली
कंडीशन सेकंड केस डिसीजन
सर एटा देला ओइला 2017
आपण टिके आगे से सुप्रीम हाई कोर्ट डिसीजन ओरा को जे करंतु डील करंतु
सर ना मोर
सर सर कहउछंती मु केते थर कहबी आपण पारा 10 डील करो फर्स्ट यू deal with those 10 judgments cited by the Lord trial court. आपण भाबुछन जे सब जहा नेता करि परियो सेंति हे परियोनी अरे लार्जर देन लाइफ इमेज कोड कोर्ट को जज से जो जे सेटा सेंति होइनी आज्ञा आई हैव टू गो बाय द बुक
सर
पारा 10 रे जोटा से साइट करछंती डिसीजन हाउ डू डिस्टिंग्विश दो डिसीजंस
सर
पास संतोष कुमार तराई कोंतु
संतोष कुमार तराई के आई एम गोइंग टू only sir OLR 2007-1-442 Rama versus Tapasini.
नहीं आपण संतोष कुमार तराई कले रामो काई जाउछंते आज्ञा
sir I have not
तराई versus जयश्री साहब हाउ डू डिस्टिंग्विश
I have not gone through this
okay nothing can be done sir
those
never by reading Ismail Rajesh versus Neha tapare hatat कहबे भगवान दा don't do that because that is directly against you
sir I am having something that I have gone through this cited by the petitioner. I have only gone through
the language is very see the magistrate is required to exercise the discretion in a just manner.
Sir.
The income of the wife also must be put in the scales of justice as against the means of the husband. The object of these provisions being to prevent vagrancy and destitution.
Sir.
The magistrate has to find out as to what is required by the wife to maintain a standard living which is neither luxurious nor penurious, but is modestly consistent with status of the family. Now I have to give a finding that 2,000 per month for the lady is luxurious and not the status she was enjoying. Must understand what is the onerous task on me as a court. At least I am happy that you spend some time in discussing in the court.
Sir,
and you are so candid in telling that you have not read, you have not gone to a senior. But I always hope and trust that you will read and read the case law completely.
So my last
in a case law method study, for paper you have to read at least 30-40 cases.
Yeah.
So 30 papers means you have to read around 1,200 cases.
Sir, I have read the OLR 2007-1.
Sir, OLR you have to read Santosh Kumar Tarai. I cannot close my eyes if Santosh Kumar Tarai, Sanghamitra Maharana, then Sanjeev Kumar Parida. So these decisions I cannot close my eyes because I am a high court.
Maybe I am submitted.
So if for another case you argue these points there.
No, my submission because the last submission.
So when you will put your argument to rest, you have made an effort. That's enough. Yes, what you say?
I have made last submission because I have gone through the OLR 2007-1-442.
Sir, by going through OLR, that you have to say that Santosh Kumar Tarai has been distinguished or Santosh Kumar Tarai has been set aside or overruled. Then you have to say that Sanghamitra Maharana has been overruled.
Sir.
Or you have to say that Sanjeev Parida has been overruled.
Sir, in this
to do that, I cannot just simply close my eyes. Please appreciate.
Honorable High Court.
Now give chance to the other side. Yes, what do you say?
I have filed RCFM 375/20 for enhancement the order minor maintenance.
That is listed.
That is not listed, madam.
So whether you want enhancement or that much you will do, I'll dispose of both the cases.
That much is enough, madam.
Yes, Mr. Donnaik, at least you have achieved that he is not pressing his maintenance for enhancement, case for enhancement.
So my last submission because honorable court politely.
No, sir, I have given you adequate time. You must consider the kind of preparedness. You are citing Rajesh versus Neha. You are citing Bhagwan Dutt. Those cases the court is having at least. You should be satisfied with that.
Let me, sir, one to mean, sir.
ଆପଣ ଯାହା କହିବେ କୁହନ୍ତୁ, but you must realize the time consent also is a factor for the any court.
ସେ ଓଏଲା 2007
ଆପଣ
1 ରେ
OLR ଆଗ ଆପଣ you can't insist upon ମାନେ not reading ସନ୍ତୋଷ କୁମାର ତରାଇ, ସେମିତି କଣ ହେଇପାରିବ? They cannot.
ଠିକ ଅଛି last submission before is honorable court that
ଆପଣ ସେ citation ଟା କୁହନ୍ତୁ, ଆପଣ ତ ପଢୁନାହାନ୍ତି, that's the problem now.
Honorable court failed to understand the interpretation of legislation.
ସେଟା କହିସାରିଲେଣି, ହଁ ଏଟା ବହୁତ ଭଲ କହିଲେ, ବହୁତ ଭଲ କହୁଛନ୍ତି, ଇଟ୍ସ ନଟ୍ ଏ ପବ୍ଲିକ ଫୋରମ ଫର ସ୍ପିଚ, ଏଟା ଟେଲିଭାଇଜ ଯଦିଓ। ଆପଣ ସେ ସାଇଟେସନ ଟା ଆଉଥରେ କହିଲେ ଯୋଉଟା କହୁଛନ୍ତି, ଯୋଉଟା ପଢି ନାହାନ୍ତି।
ସେଟା ସାର୍ ମୁଁ ସାର୍ କହୁଛି 2007 ଭଲ୍ୟୁମ 1 442 ରେ
ଆରେ ଆସ୍ତେ କୁହନ୍ତୁ, ଆପଣ ଗୋଟେ ପେଜ ରୁ ପଢୁଛନ୍ତି, ଆପଣ ତ ବହି ଦେଖି ନାହାନ୍ତି। 2007
442
2007
ଭଲ୍ୟୁମ 1
2007 ଭଲ୍ୟୁମ 1
ସାର୍
ସେ ସବୁ ସାର୍ କହୁଛନ୍ତି, ଆପଣ ଭଲ୍ୟୁମ 2 2007 ଭଲ୍ୟୁମ 2
That's a volume 1, 442 Roma versus Taposini. The Honorable High Court stated that the expression unable to
Did you cite this decision? Did you cite this decision before the trial court?
No, sir.
Okay. आरटा मगन
Argument 375 over 25.
But that आनंद रेस्क्यू से आनंद तापोटा तो का मीटिंग ଅଛି counsel for the petitioner Mr. जल्दी करो तो जगबंधु पटनायक for the petitioner Mr. Rajiv Bihari Mishra. Rajiv Bihari Mishra for the opposite party. RPFM 13 of 2025 along with RPFM
375 over 25.
375 of 2025. Both the aforesaid RPFs arise out of a common order, common judgment passed by the Lord Judge Family Court Puri 26/11/2024. When I constantly लिखिए the RPFM 13 filed by the husband challenges a special notice कर दे, है ना? Challenges the judgment denying the grant of maintenance. The RPFM 375 seeks for enhancement of the maintenance awarded by the learned trial court. Stop. By the said judgment, the petition under section 125 CRPC. Can I request Mr. Gonnai, can you sit and so that if you do, I'll take some time. You sit and listen. No different. You need not have to stand. Mr. Mishra, you also sit. Yes, you are still visible. You are still visible. You can see yourself. Filed by the opposite party in the RPFM 13. Seeking maintenance of rupees 30,000 per month for herself and the child in her womb when she filed the application before the learned Judge Family Court, Puri. The marriage between the parties, the RPFM 375 of 2025. 375 25
Notice has gone on limit.
Not listed. But since the matter is extensively hard, you file that memo. Memo ta file करंतु जी जति amount अछि सेति करे आपण दे दे। कोई कागज दियौ सर। ତମେ ଲେଖା ନେଇକି ଆଣ ସେ ଫାଇଲ କଣ and it is mentioned by the learned counsel for the petitioner that the opposite party in the RPFM 13 would not seek further enhancement of the maintenance as of now. The records of the connected appeal, connected RPFM, connected petition now, connected petition arising out of the judgment is called for. But memo of date is filed by the learned counsel for the opposite party in RPFM 13. Petitioner in RPFM 375, indicating that the amount of maintenance awarded by the judgment dated 2011-2024 is not sought to be enhanced by the opposite party wife, opposite party petitioner wife for the present. The learned counsel for the petitioner in RPFM 13 on behalf of the husband, the marriage was heard in extenso, who addressed arguments being present at the virtual court, High Court of Orissa. At Puri. He raised the following contentions. One, the maintenance under section 125 CRPC could not have been awarded for a child who was in womb during filing of the not during when the petition was filed claiming maintenance. Two, in view of the judgment rendered by the Honorable Apex Court in Rajneesh versus Neha, the battery charge करेंगे. AIR so and so, so and so. The wife has not proved her income and she could not have been awarded maintenance. Three, for exercising jurisdiction under section 125 of the CRPC, the wife has to prove that she is unable to maintain herself and the minor child. Four, the legislative intent of enactment of 125 CRPC is that the wife must prove that he is unable to maintain herself. Regarding this contention, the petitioner relies on Bhagwan Dutt versus Kamala Devi, colon AIR 1975 SC 83, colon into bracket 1975, bracket close to SCC 386. ଚାର୍ଜର ଆଣନ୍ତୁ ଆପଣ ସିଏ କରିବେନି, ଆପଣ ଏଠି ଯାଆନ୍ତୁ, ଏପଟେ ଯାଆନ୍ତୁ। Para. Regarding the first submission that about a fifth लिखिए, the learned court, the conclusion arrived by the learned court is not in consonance with the judgment rendered by this court into bracket 2007 bracket closed Roman 1 OLR 442. Para. बंद करूँ अच्छा पार्टिसिपेट कर बंद कर दूसरी पारा to answer to delve into the issue whether the child should have been awarded maintenance as the child was in womb. This court has examined the judgment at length. Apparently, no such plea was raised when on the date of argument, that is 12/11/2024. Inasmuch as the marriage was solemnized on 9/7/2022, and by 12/11/2024, the child was already born. Stop. Significantly, the petitioner did not make the unborn child as a party and stated in the petition that she is claiming maintenance for the child in the womb born from the marriage. The following issues were framed by the learned trial court. Para 4, page 15, internal page 4. For determination as per the pleadings of the parties and the evidence adduced. The present petitioner had examined himself and also examined another independent witness on his behalf. The witnesses being OPW1 and OPW2. As has been recorded by the learned trial court, the OPW1, petitioner, OPW1 dash petitioner dash opposite party before the learned trial court had himself stated that after birth of the child, he had visited the opposite party petitioner. regarding desertion by the opposite party, dash petitioner dash wife. The following finding has been given by the learned trial court. Para 8. At para 8 of the judgment, which is reproduced here. So, quote kardele, quote pare. It would be evident from the above discussions by the learned trial court that the petitioner has not voluntarily rejected the society of the opposite party without any reasonable cause. First, for a second point, what argument out there? First page to the The learned counsel for the petitioner has relied on Rajneesh versus Neha Chopra to argue that in view of the absence of evidence as to income of both the parties, the learned trial court could not have awarded any amount as maintenance. On being asked whether that is the mandate of the Supreme Court, that is the mandate of the said decision under Article 142, that in case of absence of pleadings by both the parties, absence of evidence by both the parties, as is the case, is that is no documentary evidence was adduced by any of the parties. Stop no, semicolon. The court could not have proceeded to decide the matter to award maintenance. It is fairly considered by the learned counsel for the petitioner that that is not the mandate. Para. Significantly, comma, in the present case regarding the income of the petitioner opposite party husband. It has been a factual finding has been given by the learned trial court that the OP has filed, the opposite party as petitioner, husband in the marriage has filed the affidavit of his assets and liabilities, which was taken note of by the learned trial court. Para. The oral evidence rendered by the petitioner, the opposite party wife, regarding income of the husband, petitioner herein, as well as the evidence of father of the wife, then evidences of PW1 and PW2. Evidences of PW1 and 2 could not be dislodged by the present petitioner. पारा तापर नेक्स्ट पॉइंट देखो कॉन्डक्ट पैकेज लिखना आते पहुंचेंगे the learned counsel for the petitioner relies on the decision rendered in rendered by the Supreme Court in AIR 1975 in Bhagwan Dutt versus Kamala Devi. तापर साइटेशन लिखले साइटेशन आगे डाक्तिली हला लिखि दे जा से रहला बस सुपरा कर दियंते सुपरा Paragraph 18 and 19 of the said decision, into brackets, SCC print, are reproduced herein. Having gone through the judgments rendered by the trial court and the reasonings given, which are based on the evidence on record, it has to be held that कौन लिखला उतरे पढ़ो तो the principles laid down in Bhagwan Dutt versus Kamala Devi has been followed. By the learned trial court. Relevant paragraph of ita quote kar debe. In Rajneesh versus Neha Supra, the following has been laid down. The pore paste kara diyo. ବର୍ତ୍ତମାନ ଆଉ ଥରେ ମୁଁ କଲେ ଆଉ ସମୟ ପଳେଇବ. Next point question. The legislative intent, legislature has been very aptly captured in the language of the Honorable Supreme Court in paragraph 19 of the Bhagwan Dutt Supra. Paragraph which has been reproduced above. The judgment rendered by the trial court cannot be faulted with on these grounds as canvassed vehemently by the learned counsel for the petitioner. Next point. Yes. Since it was stated by the learned counsel for the learned counsel for the petitioner that the conclusions of the learned trial court is not in consonance with the judgment of this court into bracket 2007, then volume 1, 442. The learned counsel was asked whether the said decision was cited before the learned trial court. The learned counsel very fairly submits that it was never cited. But further, the learned counsel it was asked to the further it was also pointed to the learned counsel for the petitioner that whether the decisions relied on by the trial court page 20 para 10 रे अछि जोटा इन संतोष कुमार पूराटा लिखिबे नेक्स्ट लिखिबे संघमित्रा नेक्स्ट लिखिबे संजीव कुमार परिडा where in any manner distinguished for not to be followed, which are binding on the learned trial court as well as this court in this proceeding, in the present proceeding. The learned counsel for the petitioner candidly stated that those decisions have not been distinguished. In view of the above, the learned counsel for the opposite part, the petitioner in RPFM 375 of 2025 does not want to press for enhancement of the amount. Therefore, without expressing any opinion on merits of the said petition, the petition is disposed of. In view of the above discussions, the RPFM 13 of 2025 being devoid of any merit is dismissed. The amount due payable to the opposite party petitioner, if not already paid, shall be paid within. How much time, Mr. Garnaik?
That execution petition is posted for 7th February for filing objection regarding the amended
Shall be paid before the shall be paid before the learned executing court by the next date, that is 7th February 2025.
17th February.
17th February 2026. Copy of this judgment shall be forwarded to the learned court, the learned judge, family court Puri, to be tagged to the records of the execution case. Mr. Godnaik?
My lord.
Number? Please tell the number again.
Number criminal execution number 20, 2025.
CRL EXE.
Sir, case number 20/25 and criminal execution case number.
Yes.
and criminal execution case number 21/25. जोड़े सा फाइल क्वेश्चन सर.
nomenclature ଟା author ଟିକେ kindly କହିବେ CRL EXE
EXN dot case. CRL dot EXN dot case. Sir, EXN execution.
अच्छा ठीक है
Dot case number.
not EXEL EXL
EXNN.
L for
EXN সেটা execution EXNN
N for north अच्छा oh yes
Case number 20/25 and another is 21/25.
yes thanks for your time Mr. Gondak.
Village.
Yes please. So that takes care of both the there will be some further little bit of addition reasoning but largely this is the judgment. I have tried to pronounce so that at least you'll be satisfied it is pronounced in open. So lage jaye three jon ekadi bandi ki de debe. Rest of the matters to be distributed.
ଆମଟା ଟିକେ ଜଲ୍ଦି ହେଲେ ଭଲ ହୁଅନ୍ତା ଆମର ଛୋଟିଆ ମ୍ୟାଟରଟା ଫ୍ରମ୍ ଦି ଡେଟ୍ ଅଫ୍ ଆପ୍ଲିକେସନ ହବା ଦ୍ୱାରା ଫ୍ରମ୍ ଦି ଡେଟ୍ ଅଫ୍ ଅର୍ଡର କରିଛନ୍ତି ଆଇଟମ 31
37 ଟା କଣ କହୁଛନ୍ତି
31
ସେ ଗୋଟେ ମେନସନ ହେଇଥିଲା ସେଟା କୋଉଠି
जो असेंबली
ଆଚ୍ଛା 37 ଟା ଦିଅ ସେ ଡେମୋ କିଛି ଦେଇଛନ୍ତି ମିଷ୍ଟର BC ସ୍ୱାଇଁ 37 ଲେଖନ୍ତୁ ତାହେଲେ The BC Swahi on behalf of Alok Kumar Mohanty for the petitioner. 37 Mr. Sushanta Boral is appearing for. You are present.
I am appearing.
Yes, for कहाँ पे?
Sir, opposite.
The state given now. 37 में की में अच्छी Mr. Sahoo, Mr. Sethi.
yes
Mr. Ansuman Sethi, but ଆପଣ सोसाइटी ପାଇଁ
ହଁ ସାର୍ ଆମେ ଇନଷ୍ଟ୍ରକ୍ସନ ପାଇଁ ସେ କାଉଣ୍ଟର ଫାଇଲ କରି
ଟିକେ ଫୋନ କରି ପଚାରି ଦଉନାହାନ୍ତି ଆପଣ ସେତେ ବହୁତ ଜଣ ପାର୍ଟି ଅଛନ୍ତି 31055 ରେ 6 ଜଣ ଅପୋଜିଟ ପାର୍ଟି just 1 second ଗୋଟେ ସେଟା ଯେହେତु ଫାଷ୍ଟ ଆୱାରରେ ମେନସନ କରିଥିଲେ ଅର୍ଡର ଡାକିବାକୁ ପଡିବ ମିଷ୍ଟର Ansuman Sethi for OP number 125
Lordship, on last occasion, they were supposed to file for rejoin.
So because it relates to purchase of paddy, I don't have jurisdiction. That they are saying. It is submitted by Mr. Swain Audit Council on behalf of the Mr. Mohanty for the petitioner that the matter relates to procurement of paddy from the petitioner, who is a farmer. Since the said determination is not within the determination of this court, since the said subject matter, determination since the said subject matter is not within the determination of this court, the matter shall be placed before the registry to do the needful. Yes. Mr. Chakravarti, item
31 from the date of application of a from the date of order କରିଛନ୍ତି 20 ମସିହାର କେସ୍ without assigning any reason.
Application से जो citation ଟା ଅଛି ସେଥିରେ
Rajneesh versus ଅଛି ସେ ରିପୋର୍ଟରେ ଅଛି ବି ଡିସିସନ ଟା ମୋ ପାଖରେ ଅଛି
right 31 ଟା କେବେ ଆଣି ପାରିବ ସବୁଡାକା ହେଇ ଯାଉଛି but only 16th week ଟା ଟିକେ ଛାଡି ଦିଅନ୍ତୁ some difficult
ମୁଁ କରିବି ସେଟା କି ଯୋଉ ଛୋଟ ମ୍ୟାଟରଟା ସଲ୍ଭ
we commencing କେବେ କରି ପାରିବେ 2 ହେଲେ ହେଇ ପାରିବ ହଁ ठीक
ହେଲା ଆଇଟମ ରେ last item
40 yes
date may be fixed short date
what is neon to sir if we start seriously hearing this will be the issue please appreciate but though he is courageous but we didn't have that kind of courage that we don't look at the I mean that has happened in our bar also. I mean at times youngsters are not going to the seniors. No, I have since the court of proceeding is over. I'll tell something personal.
item
I was now we commencing now we कर रही था ଆପଣଙ୍କର ମିଷ୍ଟର ମହାପାତ୍ର ଆପଣଙ୍କର
Item 29 ଟା ଆମେ pursuant to the order of this honorable High Court 112 50,000 already paid and 5,000 ଦିଆ ହଉଛି ତାକୁ।
So at least sir he is listening to you. They are not listening to lawyers. So what do you want now?
ଆଉ ଛାଡ଼ିଦବା ଆଉ।
29 କେବେ କୁ କରିବେ? Week commencing 3 ନା କେତେ? 2-3 Other matters, whatever if you are suggested date or he will be distributing it.
Interim order to continue ହେଲାଣି।
नहीं order କିଛି ହଉନି। Better ହବ ସେ posting କରିଦେବେ simply ଆପଣ କିଛି mention କରନ୍ତୁନି। କାରଣ I am not passing any order to modify or to change anything. Yes.
Item 38.
ଆପଣ कहाँ पे? Mr. Bora?
Opposite party 6.
हाँ ठीक है। I could guess it. OPC इसके बराबर। आपका नाम क्या?
S. Kohar.
With along with Mr. S. Kohar. KNHI. जोटा आपनकर business before the assignment. Yes.